Good morning. Good morning. Good morning. Good morning. Good morning, Bougie Gang. How are you? It's still a little early, y'all. I've been out and about like a scout on the route. No, I'm just kidding. Um, After I dropped off at school this morning, I have been out and about, period. So I said, let's go ahead and get an early start. If you missed me over at Love Lies and Lace Fronts, you would not be wrong. Like I said, I had a doctor's appointment this morning. So I went from that and came straight to do this. I did a live in members this morning on this channel to talk about something specific, which was this. This happened yesterday, and I thought this was very interesting. Good morning. Hi, friends. Hey, y'all. Good morning. Hi, Bougie Gang. Good morning, good morning, good morning. If you're in membership, then you already know we talked about this a little bit. I had to go to my doctor's office this morning. Miss Ma'am needed to see me. I got a clean bill of you're doing amazing. Okay. All right. And I was talking to you guys about this that happened yesterday. Now, I hate to say it because I feel like some of you guys might want to watch, but I feel like I'm not going to bore you with all of the details. Judge Simpson is the standout as usual. Judge Simpson. Um, this is the thing I like about Judge Simpson. He asks a lot of questions, and he doesn't just ask highbrow legal questions. Like he almost asks the questions like we're wondering at home. I like him a lot, so he asks a lot of questions because he's really seeking to understand and get to the root of the problem. And I think that's why people like him so much because he's so common sense and so, he's just so good. Anywho, he is presiding over this case at the moment. And yesterday, Sherrone Moore, who is the football coach from Michigan, his lawyer filed a motion to really dismiss the case for a couple of reasons. One of which, and I'm going to just kind of high level it. If you want more detail, um, this hearing went on for about an hour back and forth of like, different legal arguments that I found quite compelling and interesting. I just don't know if you guys are going to be super duperly interested in it, but I thought Judge Simpson's ruling was if you guys say now, no, Fran, we should run it, but it was kind of long and they did take a break. Um, but basically, what his lawyer argued was that there were some key components missing to the affidavit. And when the magistrate made the decision to issue the warrant, there were key. Why did Amazon just have to drop off? It's like Amazon, please. You're kidding. Okay. So there were some key components missing to the affidavit, and that would be the reason why. That would be an extenuating reason, or maybe that's a reason why they feel like there's some flaw because there were some key omissions in the evidence that was submitted that really made Sherrone look stalkerish, right? And one of the key bits of information that was missing was the fact that they worked together. And can you please, ma'am, can you please go? It's like, my God. So you know what I'm saying? So there were some key components missing, and they feel like because those components were missing, and maybe some unspoken things, I'm gonna, you know what I mean? It's not look, it is not out of the realm of possibility that a woman saying that a man is stalking her, a married man she's having an affair with, a married man who's having an affair, who is getting ready to be fired from his job, um, could be stalking you potentially, right? And yes, he did say, he didn't call it lies of omission. It was more that there were some that it could potentially have been done maliciously. or some maybe to make the complaint sound a little more salacious, because of the nature of the phone calls is really still undetermined. And considering that this woman was on the clock, still working for this guy was still in his position. It was a work day. She was not at work, and said, everything wasn't necessarily a personal call. That with that omission of the nature of their relationship outside of a romantic relationship could have been information that the magistrate needed to use to make a determination as to was there harassment. And if it's deemed that there was not harassment, then there is no stalking, right? So I was like, this is really a good argument. It was so HR. I was so into it. Um, he was calling during work hours. Now, was it all work and no play? We don't really know that. But even some of the questions that the judge asked were questions that would be questions that would matter because of the working relationship, and because that particular very important key fact was not included for because you can't assume that the magistrate's like, oh, I know who these people are, I know how they work, I know what their structure is, I know. What his lawyer is saying is that there was no harassment, and that these were calls that took place during the workday, and he could have been making a personal call, but there's nothing that establishes. And the way that this complaint was written, which they say it was heavily written by Miss Ma'am's attorney, or it comes heavy from the statements of Miss Ma'am's attorney, then anyway, I don't want to ruin it for you guys. If you guys want me to, it's going to be about an hour of motion back and forth. If you guys want to go into it, I'm cool with that. I was going to just go straight to Judge Simpson's decision, so I don't have that queued up. Let me see. Let's see. You guys want to watch that? Now, this was it was, let's see. I basically just told you everything that happened. Um, Girl, she looks like she had a hard night at like a good Cinco de Mayo party, okay? Like lots of tequila, lots of music, some good food, and I'm throwing my hair up in a messy bun on today. You know what I mean? Like she looks like she had a good time the night before somewhere doing something, okay? And thought she put herself together, but did okay. Hold on a second. Okay. If you got, we're gonna get into it. I'm happy to play. This is gonna get, it's very much emotions, right? So, but I know you guys like the um legal back and forths. I'm gonna probably take myself off screen because we can have ligation. And but let's get into it. You guys want to see it? I'm cool. Um let's see if we lag at all. If we start lagging, I'm going to drop, okay? But I love to say hi to you guys. Hey guys, good morning. Let me see who got here first. Um Y'all, oh, remember I told you about the lady Susan Perry here, who is accused of killing her husband. He died like 3 months ago, Joe Perry, in Huntersville, North Carolina. Well, guess who got out on bond? Okay. Ma'am has a murder case and she's out on bond. I think I told you guys, don't tell Nesto. But ma'am is out on a murder case with a bond on house arrest and family supervision. I was like, baby. Hold on. Where's my bongos? Girl, let me get my bongos out. Okay. Don't tell Nesto. Okay. Ow. Don't tell Nesto. Okay. Because he gonna be mad. Okay. Hey, boo. Good morning, friends. Good morning, friends. Don't tell Nesto, okay? Justin She's a lady. I guess you know what? I do think that women get bond more than men. Um But Nesto has made himself persona non grata in Fulton County, so he can't get the same consideration everybody else does. I mean, when you're coming in and you've got 150,000 cycles, they're not really trying to give you bond, right? Right, Mons? Okay. Good morning to Keonce. Keonce got here first. We're doing a little bit of a morning show this morning. Good morning, good morning, good morning. Nesto's Handy Girl and Boothang, only me 23. Good morning. Oh, honorable mention, Boothang, Bible Lady. Let me just give everybody a shout out. Sexy RN, good morning. Hey Queen, good morning. Good morning, good morning, good morning. But let's remember it was Keonce, Nesto's Handy Girl, and only that's our 1, 2, 3 first. Okay. Good morning, Very Cherry, Beverly. Good morning, good morning, good morning, Jackson Tabasco. Good morning, all my boo-boos and bebes. Good morning, Black Swan, Ms. Lady. Girl, the busy girl. I feel like a busy girl. I'm a busy girl too. If I made up a new name, I would have to be busy girl, the busy girl 912. Okay. All right, busy girl 912. Greetings from Jajamin. Okay. Let's see. Petty Patty. What's going on, hun? Honey, say that. V the one. Good morning. Good morning. Good morning. Good morning. Amy over there on Facebook holding us down. All of my Facebook boo-boos, thank you. Gigi, Di, and Delmasha. Good morning. Good morning. Good morning. Good morning. Good morning, everybody. Let's see. I think I got everybody, did I? Gigi's over here. Gigi, good morning. Blue 3, Sapphire. Let's see. Oh my God. Can I tell you something really quick before we get into it? I know we need to be about business because we're talking about important court stuff. I came home from the doctor's office. So I got a Sam's pickup yesterday, right? I got a whole thing of burrito flour tortillas because we were going to make burritos. Duh. Anyway, why did your boy figure out a way to, because I had it sitting perched on top of like a airtight container of rice and something else, just it was just holding. Why did your boy figure out a way to knock over the rice and the almonds and get a 36 pack of flour tortillas? So when I came home, he's over there chowing down on a whole pack of 36 burrito size flour tortillas. Portia's laid out looking like, mommy, I just had one. Okay. And so, needless to say, I grabbed them. I don't know how many he ate, didn't eat. I just picked him up. I threw him away. Greedy, greedy. Okay. I picked up the rest, threw him away. He had like a stack in his mouth. And I just immediately let them go outside. And I let Portia back in. And as she was coming in, Lambo goes and runs out to the yard. I guess he dropped his stack in the yard. He went and had the nerve to pick up a tortilla and was going to try to bring it in the house. I was like, if you don't eat that damn stolen burrito outside, you going to eat that outside. Your boy I mean, you would think, and he got fed. I gave him 2 cups of food. I gave Portia a cup of food. Portia gets a cup. He gets 2 cups. And then they have one of those slow feeders. I put a cup of food in the slow feeder. Everything. They get fed first thing in the morning, y'all. So don't like, oh, he must have been hungry. You didn't feed your dogs. Baby, I'm not new to this. Okay. I'm OG. I'm almost 20 years in the game. Okay. My last baby passed at 17. Okay. So I'm not new to this. I'm OG dog mommy. Okay. Sir had his food and everything and still stole some food. Okay. He's just like that. Okay. So I just wanted you to know what your boy was doing early this morning. Okay. when he should have been watching the house and being good while mommy was gone to the doctor's appointment, he was over here stealing food like he doesn't get fed properly. And that is not the case. Or else it wouldn't be on his doctor's report that he's like almost 10 pounds overweight. Okay. Okay. Because he's 61 pounds and he really should be a little lighter. But he stays hungry. So okay. All right. Good morning, everybody. Good morning. Good morning. You know what I'm saying? Dang, Lambo. Okay. Dang, Lambo. Yep, he sure did. All right, guys. Let me put this up. We'll talk about it as we go. This was very interesting, y'all. And Judge Simpson asked such good questions because these are going to be questions you're going to be thinking about. But he's getting them to talk it out. Okay. All right. Let's go. I might increase the speed just a little bit. Okay.
Washington State of Michigan is now back in session.
Hold on. Ooh. Okay.
The Honorable Judge Jason.
You may be seated.
I'm going to be number one. I like this view because this is from the Zoom hearing and this had like the best sound. If you watch this on the YouTube streets, varying different news channels had varying different quality of audio. And at the end of the day, it's audio wins hands down. Like the visuals are nice and everything, but it's the audio for me. So I know you guys feel the same way because, then we got to get into CC and all of the things. I'll put CC on. I know some of you like CC and when it's live, we don't always get CC, but now that I can turn CC on. Okay. And if you're in members, we did a live this morning, about 30 minutes. We talked about some of this. So go get into it. Okay.
Court does call the case of the people, State of Michigan versus SHERRONE. Counsel, please take your appearances for the record.
Good afternoon, Your Honor. Katie Rosworski for the people. Good afternoon, Your Honor. Ellen Michaels on behalf of Sherron Moore, who is present in court. Please state your name for the record.
Sherron Moore.
Thank you. All right, you may be seated. And I guess the first order of business, Counsel, this is your motion for a Frank's hearing.
I also like this view because it's the Zoom and we get to see the judge. So we get to see, what I'm saying? Like I think it's a good view.
And I'll let you go ahead with that. There was, however, a motion that you had filed, I think, latter part of last week, requesting permission for the court to accept a reply brief. Did the people have a response to that? I will.
If you want to know what's going on, I just explained it. So go back before Lambo thievery story. And we talked about why we're here, what is going on with Sherron Moore and what this motion is all about, because his lawyer, in a nutshell, filed a motion that basically the evidence and information that was used to issue the warrant for his arrest was flawed because there was a really important bit of information that was not included. And on its face alone, basically the allegations can look stalkerish and harassment-ish. Okay. But if you take into account that this is someone who works directly for this individual and all of the things, this was an omission that was not recognized and were not flushed out to adequately weigh the evidence versus the allegations, right? And because of that, his attorney very smartly, I think is, strategic wise, this is a very good move because she worked for me. Every call was not me. Every call wasn't a boo thing. Hey boo call, some of the calls were actually about work. And also, I think where he is going to say that it was potentially disingenuous, maybe there was a lacking of the phone log. It was very strategic the way that the receipts were provided, and it made it look, it gave what it needed to give for the charges that they wanted, but had they included everything, there could possibly have been more questions. And to his attorney's argument, there would, it's not harassment, and if there's no harassment, it's not stalking. So let's hear it. Okay.
I'll just say this, the information, the legal information contained in there, I already had done the research, so I knew it.
Agreed, and same, and the court can take it for whatever the court thinks its import is. I plan to respond to it, if only briefly, orally, if that's acceptable.
That's acceptable to the
Thank you.
court. All right, very good. All right, thank you. Proceed.
Good afternoon. May it please this honorable court. Thank you for accepting my motion in reply to the prosecutor's response on this issue. The importance of the reply that I filed is that it states clearly and unequivocally that the relationship between the parties in a stalking allegation matters. It's not stalking if the communication has a legitimate purpose. As stated in my reply, and as what your honor knows, is that under recently published appellate court case in the state of Michigan, it is clear that the relationship between the parties matters. In that case, there was a stalking charge and there was a trial. At trial, the evidence presented that the alleged victim was a probation agent and that the alleged defendant was a probationer. The probationer contacted his probation agent many times, to the point where the probationer said, "Please stop contacting me." The probation agent felt harassed. She had her stalking charges filed. At a bench trial, there was a finding of guilty. On appeal, the appellate court stated that the employment relationship is relevant, or excuse me, that the relationship between the probationer and the probation agent is relevant. That it's relevant because what it shows is that contact between the two parties had a legitimate purpose. The contact was for the probationer to notify his probation agent of certain things. What the court said was that when looking at the reasonable person standard of whether somebody feels harassed, you have to look at whether a reasonable person in that position feels harassed, which gets us to what happened in this case. In this case, Detective Welker presented to the magistrate facts to seek an arrest warrant for Sherron Moore on stalking charges and on home invasion with intent to stalk. In the facts that she presented to the magistrate, she left out the information that Sherron Moore was the boss of the complainant. The complainant was the executive assistant to Sherron Moore, who at the time was the head football coach at the University of Michigan. Why does that matter? It matters because the communications that were presented to the magistrate were 12 alleged phone calls that were unanswered. The 12 alleged phone calls were on a work day. The complainant in this case had not taken a leave of absence. She had not left her job. It was working hours, and she was the executive assistant of Sherron Moore. Sherron Moore was never told not to contact her for legitimate purposes. In fact, he was never told not to contact her at all, but that's not what we're here arguing right now. I'm talking about the legitimate purpose. If there are contacts for legitimate purpose, it is not harassment. As I stated a moment ago, the phone calls went unanswered. So there's no evidence as to what the intent of those phone calls were. I can tell you that there was evidence in the police reports that were tendered to me by the prosecutor's office that a text message was presented to Detective Welker by the complainant's attorney as a way to show, look, he's contacting her and she is feeling harassed. It was a screenshot of several text messages. In those text messages were several
You're
messages.
talking about one before December 10th?
There was a screenshot of messages where there was messages from December 9th and December 10th, the days that the alleged stalking occurred.
That were presented, you're saying that there's in the report, because by design, I don't have the police.
Correct.
Right. So are you saying in the police reports, there are text messages from, what would it be, the 8th and 9th or the 9th and 10th? But prior to the 10th?
Correct. Yes. The police report is where I obtained that screenshot that I presented in my motion. That's how I know Detective Welker had that information, because it was tendered to me in the police report from the prosecutor's office.
How many text messages were in that report?
In that screenshot?
Well, you're saying that in the police report, there were a number of text messages.
There was a screenshot of a conversation. And in that screenshot of a conversation that is on page 5 of my original motion,
Yeah.
there are, it starts, can you have Dave write a statement? Okay. What is the latest you can get me out? I called him. And then that would have been on Monday, December 8th. Tuesday, December 9th is one text message that says, please answer. And then on the day of the incident, it says, can you call me when you get a chance?
So what was laid out in your brief, those were text messages from various days.
Correct.
Got it. Okay, go ahead.
Yes. That screenshot was presented to the complainant by Detective Welker. Detective Welker asked her about those messages. And in the conversation, which is documented in the police report, Detective Welker was told by the complainant that the first message and the second message and the third message were work-related. The complainant confirmed that they were work-related. The one where it says, please answer and call when you get a chance, it's my belief that those text messages were also seen as work-related. Those were not part of.
Well, it's your belief, but did she say that, or?
She said to the detective said, was this work-related? And she said, yes, that's work-related. They showed her the whole screenshot. And she said, are these text messages work-related? And the answer was, yes, those are work-related. And then she was asked, are there any more text messages that you haven't given me? And the answer was no. And that's all in the police report.
Okay.
So the reason, again, to connect the dots is that there's acknowledged communication that was work-related during those days, which goes towards the phone calls. She doesn't know if they're work-related or not. We don't know if they're work-related or not. It's our position they were. It was a work day. There's no evidence to show otherwise. Because the complainant was able to distinguish between communications that were work-related. She identified the text as work-related.
Okay, let me ask this. Again, I don't have the report. Was information presented to the detective of that these phone calls were actually made?
No, It was there were no phone records at that time. It was verbally said. There were no phone records. It was
I
presented to,
understand that there may not be phone records, but was there a phone log at all?
yes, I have to look. I'm not disputing the fact that there were 12 calls made, if that's what you're asking. There were
Right,
calls made.
but here's, I guess what my point is that it doesn't indicate in the swear to that it indicates that the complainant is saying these things, but it doesn't say we look and here they are.
Correct.
All right.
Yes.
So I'm just trying to make sure what was, I guess, at that time known.
It was known that these calls, that she received phone calls from Sherron Moore that were unanswered. That's what was known.
Okay, so again, I'm just trying to clarify in my own mind. Between the 8th and the 10th, there were phone calls.
Correct.
We don't necessarily have call logs, but there are phone calls. Not that you're not disputing that. But none of these phone calls were answered.
Correct.
Okay, all right, go ahead.
At the time of the swear to, Detective Welker knew that there was an employee-employment relationship, and that wasn't presented to the magistrate.
Are you saying that that was intentionally done or just done?
I believe it was intentional, but I don't think I believe to, I don't believe that I have to prove that. I think that the fact that it is a relevant and material fact to a stalking charge makes it relevant and makes it a material omission.
Well, I have two questions for that. Do you have any case law where a hearing of this type, which we'll call a Frank's hearing, but may or may not be, but was an evidentiary hearing was then conducted based upon omissions as opposed to false or intentionally reckless statements?
I, in fact, have a case where that was the case in Oakland County, People versus Galloway. We had a 3-day evidentiary hearing based on the omission of relevant information that a tip came from a privileged source. And Judge McMillan at the Oakland County Circuit Court granted my motion for a Frank's hearing, ultimately suppressed evidence that was appealed to the Michigan Appellate Court, and that was upheld. There's quite a bit of case law where omissions are considered Frank's violations.
Okay. Okay, go ahead. Well, just one other question before you go on. In paragraph 10 of your original motion, you stated that there were, I guess, fraudulent statements that were made. And I'm trying to figure out what those may have been.
Okay.
Did you want a copy? I have.
I had a copy. Let's see. Oh, I have it right on top. I'm sorry, in paragraph 10.
Paragraph 10, you state that Detective
Yes.
Walker knowingly and intentionally or with reckless disregard presented false testimony.
Yes,
And I guess when I read these swear to, I was trying to figure out, and looking at your brief, what are you claiming that's false that she presented?
I thank you. That's a great question.
I know I asked it.
Yeah.
Go ahead.
Judge Simpson cracks me up.
Information that Detective Welker presented at the swear to, a large portion of it came from information she received from Heidi Sharp, the civil attorney who was representing the complainant in in going to general counsel at University of Michigan to disclose this relationship that is the basis of.
Hey guys, take 1 minute. Thank you for mentioning that, Bible lady. I appreciate it. Guys, likes do matter and they really, really, really help. If you're enjoying the vibe over here, I so appreciate that. And that is it's not by accident. Okay. Get into it. Subscribe, set your notifications, all of the things. But first and foremost, hit the thumbs up if you're enjoying this live right now. I so appreciate it. This was so interesting yesterday that I thought it was really important to bubble this up because yes, this is a guy who was cheating on his wife. Yes, keep your legs close to married men, right? All of the things. But this is a really interesting argument. And I think it goes into lots of different niche bubbles and arguments. So I just thought it was super interesting. So anyway, let's keep going.
This part of how we got here. This Heidi Sharp is when Mr. Moore came to the complainant's apartment, the first person that the complainant called was Heidi Sharp. Yeah. Heidi Sharp.
Hopefully that just answered your question, Sherry. Heidi Sharp is the complaining witness's attorney. Heidi Sharp is, just listen to this whole situation. It kind of is like, I totally see what she's talking about. So, okay, I'm going to go back on silence so you guys can really hear. I don't want to interrupt too much because it's very detailed and the devil's in the details. Okay, she's bringing the receipts.
Then calls 911 and says a series of statements that are in my motion that she did not have personal information of and had no basis for and are untrue.
Okay, that may all be well and good. I understand that portion of your argument. But in paragraph 10, you're saying that the detective intentionally gave false testimony, submitted false testimony.
Right, I'm
Now,
getting there. So
if I'm the detective and I'm relaying what somebody told me to the court, I don't know that that's false.
I understand. So what happened was after this attorney who was not present gave this information, the actual complainant was interviewed on 3 separate occasions at her residence, which was all on the body-worn camera that I reviewed. The body-worn camera statements made by the complainant were a part of the police report. Then there was a follow-up phone call with Detective Welker to the complainant. The information the complainant gave to Detective Welker conflicted with the information that Heidi Sharp gave the detective. So
but that doesn't mean that Detective Welker presented false testimony. It just means that, which seems to me to be at the core of your argument, that there was information that was omitted.
Well, if Heidi Sharp, who is not a witness, said something that the actual witness contradicts, then it is false. Or unless you're saying that the person who wasn't present is more reliable than the person who was present. It was contradictory.
Well, I get kind of what you're saying, but you're.
Okay, I'll take it a step further.
Okay.
Heidi Sharp stated that Mr. Moore had a long history of domestic violence against Shiver. Okay. Shiver herself never made those statements. She never gave that information. There is no record of any of that. There is no documentation of any of that. There is no criminal history. There's nothing to support that statement made by Heidi Sharp. Through 3 interviews, the complainant never says any of that. and also doesn't support it. She was asked by Detective Welker about assaultive behavior, and she said, no, there isn't any. Heidi Sharp's comments were completely contradicted, and Detective Welker, by submitting to the magistrate Sharp statements instead of the complainant's statements, was reckless and intentional and false. And the purpose of a Frank's hearing is.
I don't know. See, I'm still having an issue with the false part. I get your argument regarding what may have been reckless or an omission, and either reckless inclusion or reckless omission. It doesn't, I get that part. I don't know that. Could it be what you're really trying to point out to the court is that by placing that information in, the context of the relationship was placed in a false light, as opposed to what she said being false? Because what she says, what Detective Welker says is, yes, this is what Ms. Sharp said, right? But that's only half the story.
That is a way to look at it, but I do believe it goes a step further, that a detective is an officer of the court. It is their job to investigate. It is their job to present truthful information to a magistrate, to show the picture in order to get, for the magistrate to make a determination. The magistrate needs information to make a determination of probable cause of whether to issue an arrest warrant. That's a big deal. That's like due process at its core. And in this case, where the detective talked to Heidi Sharp and the complainant numerous times, had a picture of the whole situation, had an ability to ask the complainant if it was true or not, had an ability to ferret out what was really going on here, and then present it to the magistrate in a fair and honest way to paint an entire picture. That's her duty under the law. And in this case, the picture that she painted was inaccurate, not supported by the facts of the person who was present, not to mention the omission of the employment relationship.
I mean, we can move on from here. I mean, we might be saying the same thing in a different way, but it really isn't that it's false. It's that she may have portrayed an inaccurate context to everything that's going on by omitting certain things. I don't know that makes what she said about what Heidi Sharp said false. It's just you haven't given me everything to give context to what she's saying, whether to ignore it or not. Right?
I guess maybe the better language would be reckless disregard, which is also part of the analysis. But the reckless disregard is more accurate.
Okay. I asked the question because saying that somebody submitted deliberately false information may be a little bit different from somebody that is sort of reckless in what they present. But go ahead.
Thank you. So to get back to what we're asking for, we're simply asking for the opportunity to create a record, to put witnesses on, to create an evidentiary record, to show what they knew and when they knew it, and how it was versus what was presented. We believe that we presented enough of an offer of proof as to what was given to me in the police reports. That's the information I want to go on the record. I am not presenting anything that the prosecution doesn't already know. But I believe that in the interest of justice, a record should be made to establish the information that was given to the magistrate with reckless disregard for the truth and the omission of the employee-employer relationship, as well as the omission of the acknowledgement by the complainant that she recognized that communications between her and Sherron Moore were for business and knew the difference, and acknowledged that during these days in question, there was communications that were legitimate. And if the communications were legitimate, it is not harassment. And if it's not harassment, it's not stalking. May I have one moment? Sorry.
I just want one other question on the last point that you bring up. The relationship itself, one can have different relationships. I mean, so a phone call may be for business purposes or might not, right?
Correct.
Or there could be a communication that has a mixed purpose. Correct? I mean,
Correct.
because there are different relationships going on.
Correct.
And in viewing it, as to whether or not a stalking and the harassment occurs, the court would have to take into account that those two things can exist at once, right?
Correct. Okay. So in doing that, when there's things that we don't know, we often look at circumstantial evidence. So what's the circumstantial evidence here? The circumstantial evidence here is that it was a work day, it was work hours, the employee-employer relationship was intact. There were text messages that were work-related in those timeframes that these calls allegedly occurred. And it was, in terms of the dates involved, that was the week that Michigan had found out who their bowl opponent was, and there was all hands on deck.
You know what bowl it was?
Yeah, it was the Citrus Bowl.
You had to turn and look. No, I don't need to know. I was just asking.
I knew who the opponent was. I couldn't remember Citrus. It was a Citrus Bowl against Texas.
Bowl against Texas.
That Sunday night, they received their opponent.
Right.
It was all hands on deck. So I believe those facts are relevant. If this were August and it was a break from the program, yeah, there could be a question. But the circumstantial facts of the timing of these calls, and remember, or not remember, but I will state that at the time these calls were made, Mr. Moore had not been told not to call her and had no idea that she had even gone and talked to general counsel. He didn't know any of that. He was operating in his job.
But wasn't there a call from, or her indication not to call? Or, the statement's a little bit different than that.
The statement is, she said that she didn't want to talk about it anymore, or she didn't want to talk to him anymore, something like that. Not don't call me, not I'm never going to talk to you again. It was more vague and did not address the employee-employer relationship either. It didn't say, I don't want to talk to you and I'm giving notice. I don't want to talk to you and I'm asking for a transfer. I'm taking 3 days off of work, don't contact me. That would all be context to show that they were personal calls. None of that occurred.
I think it's important to point out what according to the swear to, at 6 a.m. on December 8th, She told him that she had nothing more to say to him.
Correct. Which is different from I'm taking a leave of absence, don't call me, I'm taking days off. Nothing about that indicates he should not call her for employment purposes. The point being is that in order for the court to properly evaluate probable cause, the employment relationship is relevant. We can't even evaluate, or we're having a whole conversation about whether or not the call was for employment purposes. The magistrate wasn't even told of the employee-employer relationship. So this conversation in itself is showing that that was an important piece of information for the magistrate to have known, therefore it's a relevant omission. And just one more piece, just going, actually, thank you.
All right, very good.
Thank you.
Mr. Zelinski.
Look, what do you guys think about that? Isn't that interesting? I mean, from a employee-employer standpoint, okay, you want to break up with me. That's why you should never be screwing around with somebody at work, much less someone that works for you. Your girlfriend just broke up with you, and guess what? You're just going to the Sugar Bowl, and now you have no one to book your tickets. You know, this is the problem. He's still trying to move on, and maybe he's salty. We don't really know, but at the end of the day, you can't accuse him of stalking and harassing you when he might just actually really be calling for you to book your tickets. Now, someone right now just thought, well, tell him to book his tickets himself. That's not his job. That's what he's got her for, right? They took the relationship from work further than it should have been. At the end of the day, work still has to happen. And it is not uncommon for someone to get railroaded. Now, this is not the let's feel sorry for Sherrone Moore party by any means, because I don't have any respect for what this man has done, and I'm not into it. But from the standpoint of women weaponizing breakups to railroad someone into unemployment, into getting dragged, take you down and get a payday, I don't have respect for that either. Okay, that's, you know what I'm saying? So that's how I feel on that. I don't respect a woman who feels like she's got to go out guns blazing because you were dead wrong to begin with. He's dead wrong. This whole situation is wrong. But this is a very interesting argument, especially from the standpoint, he's a black man in a doesn't look very diverse. Okay. Doesn't look like a very super diverse situation going on here. And the information that was provided was not put him in the absolute worst light possible. And anybody would have issued a warrant, right? Hello. But they forgot to mention this is his right hand, his executive assistant. And he wasn't even aware he'd been broken up with. So not to say he was right to go to her house. We're not even talking about that yet. But he had no concept that she's playing the breakup game with him already. So he's absolutely operating in the dark right now, which is his own damn fault because he shouldn't have been fooling around with her, period, right? But this is a very interesting argument, and it would be like, did you guys really leave out the information to just make him look like a certified clown? I mean, he is a certified clown, but even more of a certified clown who's a harasser and a stalker? Because that's what, okay. So interesting, right? Super interesting. Okay, let's keep going. I don't know if the rest of this is going to be interesting, but this particular argument is interesting. So let's keep going.
Thank you, Judge. Does the court have a place at which you would prefer for me to begin?
Now, this lawyer, girl, I'm not saying I don't know. She's the one who looks like she had 3 hours of sleep after a very good party with lots of good cocktails. She's giving, I didn't get a lot of sleep last night.
Or any specific questions?
You can start where you'd like. I guess maybe we should start where the defendant started, and that is the relevance of the work relationship.
I honestly would end there, but if you would like for me to start.
Well,
It's like, ma'am, you asked him, where does he want you to start? He gives you a suggestion and you tell him that's where you would have ended. Can you please stop with the trickery, ma'am? Or wake up, get a good cup of coffee. I don't know if she's playing in the man's face or what, but she's, baby, this is not the first. And look at Simpson. He's like, sis, I'm ready for you because we've met before. Okay. He's gonna start laughing because he's this probably the smartest one in the room.
your argument, so I'll let you go wherever you'd like.
Exactly. Let her take it.
If I pace, I think better when I'm on.
That's fine. I do this.
It's just her not so subtle asking for direction, but already, you know what I mean? Maybe that's a tactic. I don't know, but it's very annoying.
The same.
Where I start is actually not in my pleadings, and I beg the court's indulgence for a moment because there was a legal factual issue pertaining to this ask that I struggled with at first. At first it was, hey, does Franks apply to arrest warrants? I only know Franks to apply to search warrants. You know, can I wrap my brain around this? I believe Franks applies to warrants. I've gotten myself there. Arrest, search warrants. I think there's substantial body of case law for you to infer that it can apply to arrest warrants. I think what I struggled with most after that is that defendant's ask has always been that you quash this arrest warrant and that you must therefore at that point dismiss this case. And I see no legal authority for that ask. I have found no legal authority for that ask. I have instead found 2 Michigan cases that I think address the issue, maybe not head on, somewhat head on. People v. Burrell and People v. Smith. Happy to give the court citations, please, if that is of assistance. People v. Burrell is 391 Mich 124. It appears to be a 1974 case. People v. Smith is 106 Mishap 203. It's a 1981 case.
That's Mishap 203.
Say it again. 203.
203.
Yes,
Thank you.
Those cases draw a distinction between this court's jurisdiction and a case existing and your ability to proceed with that case versus the quashing of an arrest warrant. Typically, we think of remedies when a court quashes a warrant is that there is suppression of evidence that flows therefrom, right? That's what Franks is about, search warrant. They were arguing you should suppress the evidence that came from getting this search warrant. What I feel they should be asking, what I can find legal authority for, is if there had been any evidence that flowed from the issuance of this arrest warrant, that they could and should be asking for you to suppress that. But this is sort of a backwards kind of a presentation. That might exist in a situation where there was not a warrantless arrest, where they had perhaps conducted an investigation, written reports, submitted them to my office, asked for charges, gotten an arrest warrant, went and arrested, and then perhaps did a search incident to arrest, then perhaps got some statements from defendants. That would be evidence that would flow from the issuance of an arrest warrant. Should you, which I don't think you should you grant a Franks hearing here, and should you further, which I don't think you should, quash this arrest warrant, you're still left with a validly filed complaint. And while, again, I can't find exact case law to spit this exact holding out for us, what I will cite to the court is things like the statutes and the court rules that pertain themselves to, let's say, preliminary examination. And they don't talk about holding a preliminary examination and then at the conclusion of which, if the court finds probable cause to bind the defendant over, that you bind him over on the charges in the arrest warrant, you bind him over on the charges in the complaint. Because the complaint is how we start a lawsuit. Civil, criminal, that's what that is. That's the pleading. That exists. So my position is, what I didn't plead, is that even if you granted everything they asked for, you can't get to, they have not shown you authority for dismissing this case.
Well, maybe not dismissing, maybe, but what if there were not, the court were to go through an evidentiary hearing, get to the end and say, well, if the information that defendant wishes and should have been included before the magistrate, that if that information is there, there would not be probable cause for stalking, then the stalking charge, the complaint would still exist, but the stalking charge would fail. And by necessity, so would the felony, because the predicate offense is the stalk.
And then you would have held the hearing on the complaint. You would have evidence and information on that complaint and get to exercise what we count on you for, which is your decision-making to find or not find probable cause on the charges as they are laid out in the complaint.
Correct.
Judge, as to whether or not defendant is entitled to a Franks hearing, of course, my pleading and my position is that he is not. Franks talks about there needing to be a substantial preliminary showing before you make a decision to grant a Franks hearing. Honestly, in Michigan, I think we go better than that. I'll do defendant a solid and say that I don't think that he actually has to show you substantial preliminary showing for you to make that decision. I think People v. Franklin, the 2017 Michigan Supreme Court case, stands for the proposition that this is your courtroom, your motion, your discretion. You get to do that if you see fit. My position is that to do that here would be an abuse of that discretion. I will note for the record that People v. Franklin, that judge clearly had his or her own opinion about the credibility of the CI that was in question, having been referenced in that search warrant. And so in that judge's discretion, based on that concern for credibility that doesn't seem to be laid out very clearly in the record or in the written case law, that judge made that decision and it was upheld on appeal. So Judge, this is your discretion, but again, I submit that it would be an abuse of your discretion.
Would it really be an abuse of discretion if I were concerned about the context of the relationship that was placed before the magistrate? Because I'm not entirely clear why Ms. Sharp's statements are even part of the swear to.
Why is your lawyer giving a statement for you to the police? And why are you trying to pull a dummy move on the judge to tell him it would be an abuse of his power to give this man the opportunity to present additional evidence that should be considered in considering me a stalker? Can you believe this? Girl, fake deference, okay? I just say gaslight, girl. It's a whole, ma'am, seriously? You tried it. I mean, like I said, I'm not a fan or a supporter of this man at all, anything that he's done, and even the woman. I'm not a fan of either of these people, but this argument is very juicy. It's very, very juicy and interesting because they know what they like. If there, I'm not saying that there was some collusion, but there could be some bias here that was already baked in, but you're trying to filter and get the judge in and make him and guilt him into keeping things status quo rather than look at it was kind of fucked up that you did not at least give this information to be considered. Could Sherrone still be sitting there on some charges? Absolutely. But it was incumbent upon you to enter that information into the mix so that the magistrate could make a informed decision. Let's continue.
But her statements being part of the swear to creates a certain context of the relationship between Mr. Moore and the complainant in this case, right? So I'm not sure why that's there. The court, from the time I received Ms. Michael's motion, and then your response has had and looked at the swear to, has itself, before necessarily really closely looking at anything, had a concern about what was put before the magistrate. And mainly because having done swear-tos regarding stalking cases, having presided over a number of stalking cases, one of the, I think, primary things that always comes out is the relationship of the parties and the extent of that relationship. So that the court can take into account why communication may be occurring. I mean, some of the, and you know, let's say some of the egregious ones, there's no connection whatsoever between the parties, but all of a sudden it's happening. And then that creates one scenario. Then you've got other scenarios where you have.
Look, I hate to say this. This is a great point. We know that some things can be civil, right? And be criminal, right? Now, him barging into her house and not leaving and picking up a butter knife and being weird, that was a problem, right? Him calling her off the chain, knowing that that is your boss and there's still work to be done. He doesn't know you broke up with him and there's work to be done and he's calling. You secretly broke up with him to your lawyer and to the police and to HR and everything, but he doesn't know. So he's calling for maybe 2-3-fold reasons. It's like, how is that stalking and harassment and terrorizing and all of the things? And you should be afraid. He didn't know you were afraid because he didn't know he'd been broken up with. So the context really does matter because she was nervous because, girl, you just dropped a whole dime on him. So you're nervous and scared, but he doesn't even know why you're nervous and scared because he has no idea what's actually even going on. This is what I have to say. This guy got played. He played himself and he got played and he also fell for the okie doke, which is his problem to solve and why maybe he'll get left at the end of this whole thing. And I don't think his wife's even in court with him today, which, you know, she's not obligated to be there every day because this is stupid. And he got caught being dumb and a horrible husband in front of the whole state of Michigan. And yeah, the fact that she showed up with him once was enough. But the fact that this prosecutor is over here trying to guilt Judge Simpson into an okey doke move, just wait to see how this turns out because it's very good. It's very good. I'm gonna go. Oh, let's go back to it.
An estranged husband and wife with children who are contacting, and then a court has to go through an analysis about what the context were. So would the court really, would I be in error to have concerns in reading the swear to that none of that was placed on the record regarding the employment relationship, let alone, might I say, and I'm not even at this point clear as to what the duties are of an executive assistant to a head coach.
I'm equally devoid of that knowledge and information.
So you're prosecuting this case and you are equally devoid of her responsibilities in a situation where this woman is exposed to this guy for 8 to 10 hours a day as his assistant. Would you not have at least asked for a job description and read it so that you would have an idea of what she was responsible to do as you are trying to prosecute him for contacting her during a work day, even though she decided willingly for years to enter in a relationship with this man? You didn't bother to get the job description as to what she was responsible for and why he would even be contacting her? You are devoid of that knowledge. Oh, okay.
But wouldn't that information, right, but wouldn't that information be important for the court to know?
So Judge, I wonder if I could spit back to you what you have said to make sure that I
Sure,
understand.
absolutely.
Judge, I wonder if I can spit back to you. See, she's using, okay, let me buy like 2-3 minutes because I'm not prepared.
I appreciate the court's candor. And you told me to start there and I went ahead and started where I wanted to.
Yes.
So here we are, right? There is no question that most relationships have a context. And the court is correct. There is some stalking that exists in the world that is stranger to stranger, and it is what it is. I have encountered precious few of those. Most relationships have context. I think the court was very much in tune with the reality of this situation when the court earlier was questioning defense counsel and had some commentary along the lines of, but can't both things be true? Meaning, can't there be stalking and an employer-employee relationship? And the answer to that is, but of course there can. Simply because there might be some amount of communication between two people that is to be expected or a part of a job. But if it is used and abused to threaten and harass and perpetuate more and additional contact, conversation, varieties of contact, it should not negate stalking. What I will say is that I take issue with defendant's characterization of, I think you call it Eichler, E-I-C-H-L-E-R, the September 2025 case that they have cited to you about stalking. I think really what it stands for, my read of it, is it's a commentary, it's a ruling and a holding on the status of the victim in that case. In that they said, because we all know stalking is a subjective and an objective standard to it, right? It has to have made a specific victim feel terrorized, threatened, harassed, molested, that list of statutory factors. The actual victim and a reasonable person also must have felt that way. And so what this case comments on and holds is that it's a reasonable person similarly situated to the specific victim in this case. In other words, would a reasonable probation officer have experienced this kind of communication to be threatening, harassing, molesting, so on and so forth? And the court went on to comment even further about sort of what it means to be a probation officer, and that you deal with individuals on the regular who have difficulty following direction. Court went on to underscore that this communication from this particular defendant did not involve any kind of threats, did not involve going to the victim's home or place of employment. It was simply texts, and they were all able to be characterized as about probation issues. So it is while it does exist as a case in the context of an employment, if you want to call it that, relationship, it's very specific, in my opinion, to the specific roles that those two individuals played with one another.
Yeah, but that burden rests with the people to show that. Isn't that true? I mean, during the course of a swear to,
Okay, let me just do my little, based on the case that they're using, I get what they're saying, but it was a one-dimensional relationship. This probation officer was annoyed by his probationer, okay? Maybe the probationer hadn't level set the expectation of when you should and should not call me, and sir, you're calling too much, or ma'am, you're calling too much. I don't need you to call that much, or level set the expectation. I'm answering your call maybe once or twice a day, and or even just in their own mind to not be bothered. They wanted to say that this person is stalking them, but you're not stalking because you're working. This is a business phone. This is why companies give you a business phone. This is why they give you WebEx or other devices on your computer, so that if you are working from home, nobody needs to even call you on your personal phone. They can call you through the computer. If you're logged in, I need you in WebEx. I need you in whatever people are using right now, Slack or whatever y'all using, because I haven't been in corporate America in a few years. So whatever y'all using, and you work from home and people are calling you, they're not harassing you, they're not stalking you. They might be, because they want to make sure you're working and you're at your desk, or you're doing their work and you're not listening to Bougie Gang all day. But baby, that's not harassment. If your boss wants to call you 10 times, they can do that because they're working. Their boss might have told them to call you 10 times, right? So there's a reason why you also, companies really should refrain from contacting employees on their personal phones, because then you have to get subpoenas and all of those things. At the end of the day, phone logs and all of this history and the ability for the company to be able to manage how relationships are managed from a work perspective is really, really, really important. I know most people don't even think about that type of stuff, but it is. It really is. And this lady, I don't even think really investigated it from that perspective, or the investigators didn't investigate it from that perspective. Not to say that he can't be guilty, because he certainly can be, but they didn't flush out enough of it to be considered, and it's really important, right? I think he'll still lose his job. I know we haven't even talked about that. Would Sherrone Moore still lose his job if this is some sort of bogus stalking allegation? Yes, because when they interviewed him in the investigation regarding the affair and him having a relationship with his subordinate, he lied. Okay, he lied. And he was also carrying on with a direct report, which is highly refrained, and he knows better, and he would lose his job anyway. So one hasn't done nothing to do with the other. But in terms of this, this may not end up flying. I don't know what it's gonna. I love him. He's so common sense, and he's asking so many thoughtful questions to have those that need to trip on their feet just go ahead and trip on their feet. He's so smart.
that would have to be shown to the court. I don't make a presumption that it's one way or another, do I?
It would be our burden to show what it's.
Well, at the swear to, it would be the people's burden, I guess. Seeking the complaint to show that somehow those, got to give me something that says it's something other than what might be work related, right?
I guess what I would then point the court to is that this complaint warrant alleges an incident on a date. I'm not saying that when we come to prelim here, should we get to that stage and this court orders a preliminary examination, I'm not saying that I wouldn't say to you, Judge, I'm looking to expand that date range. But right now, it is alleged December 10th, 2025. And as we all now know, since we're going to what we know, defendant was fired. And what we know, according to the complainant, as is testified to in the swear to, he called her 2 times after that. She didn't answer, showed up at her apartment, barged his way in, grabbed the implements that he did. She felt utterly terrorized in that moment, threatened to kill himself, pointed the implements at her, backed her further into her apartment, eventually left when she got her lawyer on speakerphone. And even after he left, then called her, as is witnessed on body cam, called her yet again, and sent her 2 more texts. I hate you, and my blood is on your hands. So on December.
He felt that. That's not stalking. Bitch, I hate you. I threw the bitch in. I hate you. My blood is on your hands, meaning like, okay, you did me in. You killed me. You dragged me. I just lost my job. Now my wife knows all of these things. So I think like they say, context matters. I hate you. Okay, I get it. He's mad. All right. And maybe he does hate her. That doesn't mean he's going to come kill her. He said, I hate you. And my blood, the blood that he's getting arrested, he's getting fired, he's getting exposed. All of those things that are all his fault too are on her hands because she decided to report him to the job, get a lawyer, and, drive him crazy by not answering his calls. And, I don't even know. His lawyer might even say lure him to the house so that she could call the police. I mean, call her lawyer, and then her lawyer can call the police and then get him arrested and then have the whole world talking about it. So excellent job. I mean, if they sat and devised this plan, I mean, they did it because he did all of the things. Like I said, he fell for the okie doke. But he never should have had himself involved with his executive admin.
10, and as was sworn to by Detective Welker, there is more than sufficient probable cause for the issuance of a warrant that includes stalking. That's my position. I have case law because I have had individuals question me as to whether or not behavior that occurs all on one day can satisfy the elements of stalking, that course of conduct, non-continuous separate acts. And while it is an unpublished case, Judge, I find a lot of takeaway from this case. It's People v. Smothers. So it's 2025 Westlaw WL 3483111. So it's a Mishap case. It was decided December 3rd of 2025. And it talks about 3 phone calls that took place in barely over 1 hour can constitute sufficient evidence for aggravated stalking.
Were those phone calls answered?
Those phone calls were answered, but none of them, interestingly enough, were answered by the victim. They were phone calls that were made to 911 and either a city manager or a city attorney and the prosecutor's office. And they made threats against a specific deputy and specifically threats to kill. That deputy did not answer those phone calls. They were not made directly to that deputy, but they were communicated to that deputy. And that all was found to be sufficient evidence to sustain a conviction for aggravated stalking.
This guy was asking about flight arrangements to the Citrus Bowl. You're comparing a weirdo calling the DA, the city manager, and 911 and making threats against an officer to someone who was sleeping with his assistant, and he's also trying to get his flight arrangements completed. Meanwhile, she secretly broke up with him, called a lawyer, called his job, and he's getting ready to get exposed and be fired and all of the things. I don't really think that's the same thing, ma'am. I just don't. That's not, I don't know if that's the same case law.
So Judge, I think on the record of the swear to, as it stands right now, when there was no longer any employment relationship because he'd been fired, there
Yes.
were multiple non-continuous, separate contacts that constitute stalking. I mean, I have another case that has barely even 2 contacts that was sufficient for an aggravated stalking.
I just think that at the end of the day, you know, Sherrone needs to be ashamed of himself for a couple of different reasons. He was very stupid. He started smelling himself because he got one of the top jobs over there at Michigan, and he may have thought that he was better. Um, he may have just thought he was better and above, okay? And what he found out was that he was not better and he is not above, okay? And he's going to get treated, he's going to get that same treatment. And when Sister Girl decided that she was done with you and that it was going to be more to her favor to do what she did, she's done. And he doesn't, you know, he's getting a good dose of fuck around and find out. And that's his own fault. It's his own doing.
But I give it to the court if the court.
But the, I guess, were the point of those that the information by the caller was communicated to the alleged complainant?
That certainly had to have happened for that to complete that loop. Yes.
Okay. But that's not what happened in this case.
No, you're absolutely right. There were the 2 on, if we're limiting our focus to December 10th, there were 2 unanswered phone calls by the defendant to the victim before he then came over and barged into her apartment and did the acts that he did, and then left her apartment and then called her again and then texted her 2 times. Judge, I would like to address the court's seeming discomfort with a failure to place on the record at swear to that there was an employment relationship, or perhaps what has been portrayed to the court as a disconnect between what Ms. Sharp, the attorney, communicated to the detective and what the victim communicated to the detective. Ms. Sharp, it appears defendant takes issue with 3 sort of statements or comments that Ms. Sharp made specifically. One is that defendant had been stalking the victim for months. The other is that he has a long history of domestic violence against this victim. And the third is that he is a very dangerous man. What I will first say, because counsel calls all of those false lies, and cites to the fact that there is no criminal history, there are no other police reports, things along those lines. Also cites to a follow-up conversation with Ms. Sharp, wherein she says, none of the acts that I'm talking about would likely rise to the level of physical abuse in your criminal world. But Judge, I'm sure you would agree with me that there are many different definitions of domestic violence, and also simply because something has not been reported to the police or there is no criminal conviction for it doesn't mean it doesn't exist, it hasn't happened. Specifically as it pertains to a definition of domestic violence, I always think of MCL 768.27b, so that other act statute, like when we go to trial on a crime that involves an act of domestic violence and we are allowed to introduce other acts of domestic violence.
Is Ms. Shiver claiming that?
Ms. Shiver did not, on the day that she was spoken to, December 10th, get into the history of her relationship with the defendant. One person did and one person did not. Since then, there has been a lengthy additional interview and additional information, but we're not here about that. At that time, that was not something, for whatever reason or number of reasons, she was ready, willing, and able to talk about. She talked about December 10th and the fact that they had had an intimate relationship for a period of time leading up to that. So, Judge, to characterize Ms. Sharp's statements as lies simply because there isn't any adjudicated history of it, that misses the mark. There is no mandate that there be an adjudicated history of it for it to be an accurate statement, or at least an accurate statement in her mind. She goes on to talk about, a specific example she gives of what she means by that is that he has a history of threatening self-harm as a way to exert control over the victim, and that he has a propensity to use knives when he does that. So, Judge, we all know domestic violence includes a lot of things, and that emotional harm. I mean, again, I point the court to 768.27b in terms of definition of domestic violence, and certainly it could be causing harm or attempting to cause harm, but it can be placing a family or a household member in fear of physical or mental harm. It can be engaging in activity towards a family or household member that would cause a reasonable individual to feel, and then it lists off all of the stalking variables: terrorized, threatened, harassed, intimidated. That those are all under the umbrella, just in that one subsection of law, of what it means, what domestic violence can be. So there isn't any showing that what Ms. Sharp said was false or a lie or inaccurate.
Well, but I think something might be, and this might just come from the court's knowledge of how long the college football season is. She stated to the officer, or to dispatch, I think, or somewhere, that he had been harassing her for months.
Yes.
Now, if I just take months as meaning 2, could mean more, and I take it from December 10th, that means that he was harassing her as the executive assistant through the majority of the Big Ten season. I'm not sure, and that's part of the court cut. I don't know how that works, how that would even happen.
Because I think that presupposes that the harassment she was talking about is just phone calls or texts that were maybe work-related or that were work-related.
So it was there then placed to be a context. It wasn't just something that the court should ignore.
The employment.
No, that Ms. Sharp's comments. I mean, somehow that creates, or it should have created, I guess, a context to the relationship that's going to form the basis of this stalking, in essence, right?
What Ms. Sharp is saying about it going on for months, that somehow will play into what happens here in this.
On December 10th? No, on December 10th. I mean,
Yes.
Well, then why wasn't it all given to the magistrate?
Which is the meaning that they had an employer-employee relationship.
Yeah, but it's even, and again, I don't know, but I'm just going to assume that it's different than just a just an employer relationship. I mean, from the standpoint that it's almost like a CEO and the executive assistant to a CEO. I mean, the closeness of that relationship, I just don't know how the court wasn't informed.
If I had to guess, and that's a part of what's challenging here, because we have one record, which is a transcript, and we're all sort of arguing from things we think we know from police reports and investigations. But if I had to guess, I would guess that it's because the detective assumed that as a fact, as a known fact, if I had to guess. I mean, that's about as honest as I can.
No, I understand what you're saying.
Yeah, I mean, it's one of those that seems like a judicial notice sort of a thing. By that time on that day, that's my best guess.
Well, it may have been a judicial note. I don't know if it would be. All due respect to head coaches around the world, I didn't know they had executive assistants. But whatever. I mean, I didn't know, but certainly the court, through the record, is not informed of that, nor informed what that means. I mean, even as I sit here right now, and I don't know that anybody necessarily can explain to me what it is, I don't know what that relationship is. Like I said, I'm taking it from the standpoint that it's like a CEO and the executive assistant to a CEO. And that is typically a very close relationship. There's a lot of communication that happens. And as I was thinking about this case, the only thing that I could sort of in my head equate it to is myself and my judicial coordinator. And that the communication that flows there is different than I have with any other employee in this court. It just is, by nature of the position. If I'm correct in that, and I may or may not be, I think it's something that the court would have had to have been informed of. Because at some point, even for a probable cause standard, the court's being asked, as I said before, to say that, and maybe the court would have had more questions as to what the nature of this harassment was for these months, to create a context of this. Because like I said, I can look at it one way and say, okay, 6-7 games into the Big Ten season, and I can do that by just looking on my phone if I go 2 months back. And I can say, well, if I'm right about the relationship, the employment relationship, I don't know how that happens. And then I might, if I know that, ask questions about that, right? To put a proper context on these communications. So, I'm sorry, you may go ahead.
No need to be sorry. My position is that the detective testified to information that was given to her. Was there an omission of employer-employee, that fact? That would appear to be accurate. Again, my best guess is that she assumed that was a known fact. She testified to information that was given to her. The charge pertains itself currently, as we stand, to behavior on December 10th.
Can I just say though?
Sure.
I get what you're saying, but I'm looking at page 6
Of the swear to.
of the swear to.
Yep.
And starting at line 3, basically. She stated that after telling him this, that being that there was no more to say to him, that he continued to call her approximately 12 times and sent her text messages over the next 2 days leading up to the date of the incident. Now, I just stopped there. If I have, it's, and I think everybody's right in terms of there needs to be a picture painted for the magistrate. If Ms. Sharp is indicating that there's all of this other stuff that's going on, and so if I'm the magistrate, that's what I'm hearing. Then I'm hearing this, that this individual says that she has no more to say to him. And then there are these dozens of calls and text messages that occur over the next 2 days prior to this incident. Frankly, you'd be leading me to believe the negative because you're not giving me anything else.
Not sure I follow, Judge, leading you to.
Meaning
negative.
that these communications couldn't have been for any other purpose.
Mm.
I mean, because it's equally as plausible that I guess that they could be for the purposes of harassment as for the purposes of work relationship. But by placing it on the record this way before the magistrate, you've given the magistrate no alternative but to believe that it is a continuation of the behavior that Ms. Sharp describes, which I don't know if substantiated or not. That's my problem.
I think the best I can offer the court along those lines, with the exception of not having sworn to the fact that they were employed together at the U of M, that Detective Welker passed along the information that was given to her, swore to and testified to the information that was given to her.
Well, I got a problem with that too.
Yeah.
Because part of the problem is my understanding, and maybe I'm wrong, but from listening to Ms. Michael's argument, I think I was right in that. She has the other text messages from those 2 days, right? Somewhere she saw those. But doesn't say anything about them. Doesn't say anything about what those are. Yet, the one that occurs after on December 10th, well, one particularly,
Yeah.
she lays out in great detail. That I have a problem with because it seems to me, if I were the magistrate, I'm getting half the story. I'm not getting the full story. It might be one thing if what was testified to had been, well, these 10, that after that call on the 8th, there were other messages that were sent. They were work related. And then the 10th occurs. I just made that up on the fly. It doesn't seem that hard, but that's not what was said. And I'll be honest with you, I find it a problem when the court isn't given all of the information for the court to make a proper determination of probable cause. I really have a problem with that. Because quite frankly, I think that the defendant's due process rights, as well as the right of the people to be able to proceed with a validly sworn out complaint, are at jeopardy.
Does it impact the court to be mindful that investigation was then and continues to be ongoing, and that there was always the plan and expectation of getting phones and phone records and further interviews.
That, does it make me feel? No, it doesn't make me feel any better. And the reason it doesn't is because if you think you needed that, then you needed to wait. Okay. But my problem isn't what's going to be it gotten later. My problem is disclosing to the court what you have now. So that I realize whenever these complaints are sworn out, and quite frankly, whenever the court may be dealing with a moving case or a case that is, there's always this continuing investigation.
Sure.
So things can change. But so the parties come in, and what do the parties do? They give the court what they have at the moment they got it. All of that could change at some later date. So if you're asking,
Look, let me just say this too. If I called you, Michi, 12 times, you don't know me, right? You don't know me. I call you 12 times, right? It's weird. And you could call the police and say, I don't even know this woman. Why is she calling me 12 times? I want a TPO, right? So then you send it to the judge, but then the judge finds out that you are my executive assistant. That's different, because I might need to call you 8 of the 12 times. 4 of the 12 times I was being weird. Okay. But guess what? They needed to know that we have a working relationship outside, and maybe we're girls outside. You know what I'm saying? That's the problem. That's the problem, right?
does that make me feel better? No, it doesn't.
As always, I appreciate the court's candor. I am happy to answer further questions, but my position remains that even if you excise out the statements that defendant takes issue with, calls false, calls inaccurate, what you're left with still is more than enough for probable cause, Judge. If you take the recitation.
But I don't mean to interrupt you, but it's not only taking out certain things. I would then have to add certain things.
You're worried about the omission.
Yeah, I'm very worried about the omission. I'm worried about the omission because those things at the very beginning that Ms. Sharp says create that context to the whole thing. I mean, the whole thing is sort of painted by that. And
She raised a red flag. She said that he's been abusing her. He said that he's been abusive for a long time. But there's no, not to say that every abuse case has a documented paper trail, because we know that there's many cases that do not. But the lawyer tells the police that her client has been dealing with abuse for a long time. But what they fail to tell is that she's been working for the guy for over 2 years and sleeping with the boss. They wanted to put their client in the light most favorable and not even factor in a employee-employer component to this dynamic, which is really important. It's important. And going back to saying something can be criminal, something can be civil. I mean, it really could be. Yes, she may have had a claim at the job, a sexual harassment claim. Why this ended up having to go to the police? I guess because he went to the house, he was banging on the door. He barged in. That's what they say. And then he threatened himself with a butter knife. He crashed out at her house. This is really some foolishness, but I'm really glad they got this judge because he does question everything. And this is what needed to happen. You know what I mean? They fell in front of this judge because this was some foolishness. And this particular prosecutor was trying to get the okey doke through and really fall on some very convenient biases of a very aggressive Black man who is being pointed out as aggressive. He has just gotten exposed. All of these things that are his own fault. Okay, these are things that are his fault. But when she said that she may have, her assumption is that the detective may have been falling back on something that could be known unknown. At the end of the day, now you're presuming that people are making decisions based on evidence, not on the record, not in the warrant, not in the police report. And they're just supposed to make assumptions based on what you think people know and what they don't know. But at the end of the day, this is a man with lots of privilege who has a top job at the university. Okay, and making lots of money, wife at home. Like, people are gonna, if you wanted the cop to make that assumption, or you're assuming that he made this assumption, what other assumptions did he make? Was it the assumption that this woman on Face is giving a valid rendition of what's going on with the relationship because she said so? So now we're going on assumptions and not on evidence to actually arrest somebody for someone who's calling. He could have been stalking her. It's very true. But you didn't give all of the evidence for the magistrate to make an informed decision. And that's why we're in front of him right now. You know what I mean? Had that been the case, his very good lawyer wouldn't have been able to sit. If you notice, you may or may not have seen it. If you go run this back and look at Sherrone's lawyer, she's sitting there with a big smile on her face because ma'am stepped in a pile of poo-poo and she doesn't know how to get out of it. And also, she's also seeing that she's winning the argument because the judge has more questions about how this happened and what the ramifications are of what happened versus we can flush out his guilt or innocence later, but there's clearly some bias here.
I think, quite honestly, that's why Detective Walker led with that at the swear to. She's painting this picture, and it's all, I tried to look at it as objectively as I could, looking at the swear to. It's all one-sided when you look at the other part. I think courts are entitled to more than that. You give us everything, let us make the call. That's what we do. But I don't think, well, what worries me, I won't say it in the definite, what worries me is the magistrate did not get that opportunity. That's what worries. And if the magistrate didn't get that opportunity, that means what the people got may not have been a validly sworn out complaint in terms of probable cause properly being addressed, and that the defendant's due process rights might have been violated. That's my problem, or my concern. And I don't know how, which is why I asked Ms. Michaels about specific cases regarding omissions, because it's really easy if there is information that's in, and when you look at how most of the courts address it, if something comes in and it's false or it's reckless disregard for the truth, and then the court gets to the end and the court just has to ignore that and then say, oh, is there still enough for probable cause? Quite frankly, that can be a very easy analysis. I don't know well, I won't, I'll figure it out, but the analysis where something's missing.
And I don't disagree with that. I appreciated the court's questioning along those lines. I also am unfamiliar with case law that addresses that concept. My gut reaction has been all along to say that is because those are issues that are addressed at the sort of test the evidence stages, like a prelim, a bind over, trial, things like that. But that's nothing more than a gut reaction. You don't ever want to endorse hiding the ball. You know, that's not who we are. That's not what the system is. That's not what the system should be. That's not what we stand for. Clearly the court is taken with, and again, I appreciate your candor, taken with an omission to put an employer-employee relationship on the record at the swear to. I can't fix that in the moment. I continue to believe the remedy is a preliminary exam. The court obviously may disagree, and if we hold a Franks hearing on that, then we hold a Franks hearing on that. I continue to be of the position that once that relationship is over, there is more than sufficient behavior that was sworn to that satisfies probable cause for the stalking, which then satisfies an element of the home invasion third. I believe that's for sure what Frank stands for, Williams, Franklin, all of that progeny of case law, whereby if the courts are willing to still say there's more than enough probable cause here, even if I excise out legit untruthful statements, which don't seem to in any way have been shown here, not from my perspective. And if there still remains probable cause, then the warrant is valid and there is no need for a Franks hearing. Then it stands to reason to me that if the worst that we can say exists on that record is a void of a fact pertaining to their employer-employee relationship, that.
Let me say this. So sexy RN. So stalking in one day, it can happen. However, this is the deal with these two. At the end of the day, the bottom line is so she did provide some case law where stalking did take place in one day, and they were able to determine that. But this, what they're not able to determine in this particular situation is that happened because, number one, he was calling her about work-related items. Number two, and he has receipts for it, but they never bothered to flesh it out. They didn't give it to the magistrate. The next thing is that, what else was I going to say? There was another, let me see, throwing out the stalking, what keeps home invasion. And well, it would throw, if they throw out the home invasion, it was because she said that she was scared because he was, her lawyer gave a statement before her statement. Her lawyer said that he'd been abusive. When the detective questioned her, the victim, she said, no, he hadn't been abusive. That's what they were talking about at the beginning. If you missed the beginning, run it back when we're done. They talked about the lawyer for Miss Stinger or Shiver, Miss Shiver, whatever her name is, the lawyer for the victim, the alleged victim, stated that she had been abused, that there had been some abuse for a while, like he's been abusive, like he's whatever, he's this, he's that. And when the detective questioned the victim, she said she was not. Now, do victims always admit, you know, this is a victim that is actually whistleblowing at this time? Not only is she whistleblowing about behavior, she's whistleblowing about the relationship at the job. She's on it. She's telling everything at this moment, right? So why would she not own that? Yeah, he's this, he's that, he's whatever. Her lawyer was trying to make sure that she got her client what she wanted, which I guess is some relief. She got the point across, either got some charges, whatever her lawyer's goal was. She teed up the ball so ma'am could, not to use a football reference, but she teed up the ball. Okay. She teed, not football, but well, they tee up the football too, right? So teed it up so that she could punt the ball down the field. Hello. So that's basically what happened. They were talking about the conflicting statements at the beginning of the lawyer and the nature of the relationship versus the victim, but you said all of that, but you never bothered to throw in that they work together. Never. You mentioned all these things, but you never mentioned that that's her boss. That's kind of important, don't y'all think?
If there still remains adequate probable cause on that record, that arrest warrant should still stand and there shouldn't be a reason.
I think it can keep the home invasion. She can even try to keep the stalking with 1 or 2 phone calls out of whack, right? I mean, we can't say that their stalking will go out completely. But the home invasion is also based on the fact because she opened the door. He didn't bust in the door. He didn't kick in the door. She opened the door and he walked in. Okay. So they use the term like he barged in. So they call it home invasion, but she's also using that based on the fear. But what's the established fear? He was calling you for flight arrangements. Now, the fear could have been, I just exposed this man to the world. Your fear may not have been his fear. He came over there crying. They said he was crying and he wanted to kill himself. Why are you afraid? He's crying. He wants to kill himself. And what made you afraid is more self-inflicted because you just told on him. You're getting him arrested. You just got him fired. You just exposed him. She was afraid because of what she'd done, not because of what he'd done. He hadn't had a chance to do anything yet. He barged in, he was crying, and he threatened himself with a butter knife. I mean, come on. She might have been afraid, but she was afraid because she had just exposed him at this point. That's why you were afraid. You weren't afraid because of those 12 phone calls. If you throw out the harassing phone calls, which may not have been harassing phone calls, then and you're basing the fear from the home invasion on phone calls that were business calls, actually, because he can call you, he's your boss, and you're on the clock. It might not actually like the whole case is gone. Because what it was breaking and entering, or not, what is, hold on, let me find it again. Hold on. Girl, a mess. Home invasion in the 3rd degree. Allegedly unlawfully entering the victim's residence to commit a crime of stalking. If there's no stalking, that's out. And committing a crime while in the residence. The crime of killing yourself, nobody wants anyone to do that. So it is a crime, right? I guess. Home invasion in the 3rd degree is a felony. So, but the first thing they say is that the home invasion happened because he wanted to unlawfully enter the residence to commit the crime of stalking. If there's no stalking, the home invasion is gone. If there's no stalking, if there's no harassment, there's no stalking. The breaking and entering, it says for allegedly unlawfully entering the dwelling of the victim, of which whom Mr. Moore had a dating relationship, but they didn't say and working relationship. A violation of the statute in unlawfully entering. We don't know if she said, get out, don't come in, you can't come into my property, I don't want you here. If she said those things, he should have left. He should have left, period. That was dumb. But he obviously is an emotional guy. Doesn't make it right. Go back to the beginning if you're just now coming in. This is some foolishness. Okay. This is some straight up foolishness.
For Frank's hearing. And I think that's probably all I have to say on that, Judge. If the court has any further questions, please.
I do not.
Thank you, Judge.
Thank
I
you.
appreciate it. Yes,
Response.
thank you.
The first thing I'd like to address is the position the government is taking that there are enough stalking acts on December 10th after the end of the employer-employee relationship.
Okay, let me say this. When he was calling her, he didn't know he was fired yet. Somewhere in between his calls to her and him going to her house, he was informed. By the time he gets to her house, he knows he's been fired. Let's just clear that. I believe that he had been informed that he was fired. She wasn't answering his calls. They probably told her to stay home. HR probably said, look, stay home because we're going to talk to him today. Okay. I've got his termination letter. How did I get it? It's public information because University of Michigan is a public institution. It was requested via FOIA, not by me, somebody else, and it's all over the internet. Okay. He was fired for reasons, specifically inappropriate relationship with a staff member and dishonesty during investigation. That's what he was fired for. He wasn't fired for stalking. He wasn't fired for any of those things, killing himself with a butter knife. He was fired, number one, for engaging in a relationship with a staff member. And during the HR investigation, dishonesty during the investigation. If you want to go deeper into that, I'll read you the whole letter. It's not super long. But that's why he was fired. Okay. Ironclad, he's not getting his job back unless maybe it turns out she's lying. But he did admit finally to the affair. So he's dead wrong and he's out. Right. Now here we are. But the outcome of this, if she put 20 on 10 or added some saison to her story to make her story just a little betterer, or her lawyer engaged in lies of omission, and therefore wanted to create like a perfect storm of misunderstanding and railroad shaft this dude. Luckily it hit Judge Simpson, and Judge Simpson asked lots of questions, and they probably knew they were in trouble once it hit Judge Simpson, because he's gonna ask. If you know what I'm saying, he's gonna ask questions. We already know this, right? Okay, so let's finish this up because it's not too much more, because I think at this point he's gonna take a break, but then he gives his decision. So all of that's in here. We still have about we got about 30 minutes. I'm going to try not to interrupt, but that's basically what's going on at this point. Okay.
Count one, home invasion, third degree, states that it is breaking and entering with the intent to commit a misdemeanor, and in this situation with the intent to stalk. So in order for home invasion in the third degree to have survive a probable cause analysis, relying on the acts post employer-employee relationship isn't good enough. They have to show that he went into her apartment with the intent to stalk her, which means there had to have been predicate acts of stalking prior to entering the apartment. If they are now saying that the only acts that we are relying on are the acts post leaving the apartment, the home invasion fails. And it should fail because there was no stalking prior to December 10th or after is our position. That's one point I'd like to make. Second point I'd like to make, in People v. Eichler, in paragraph 6.
Counsel, can I just ask one question?
Yes.
In regard to the stalking, you may very well be right. I don't think it's the time for the court to make the decision as to prior to. But after entering, leaving, and then texting, those could be non-contiguous acts that could constitute stalking.
I agree. When he texted her and said, I hate you and my blood is on your hands, that at that moment, he should have known she didn't want him there. She didn't want you there. She's not talking to you. It's on. It's on and popping. The laws are involved. The school is involved. Everybody, my lawyer's involved. Leave me alone. I'm done with you. I quit you. Okay. She quit him at that point. When he texted her after he was notified, that's it. That's all. Right. So yes, on that, yes. On everything else, yeah, that could be harassment. Absolutely. It's not, it could be harassing. It's not stalking. And it can also be, I'm mad. We've been doing it for 2 years. I thought we were booed up. I thought we were good. And one day goes by, and now all of a sudden you quit me. You told on me. You got me fucking fired. My wife knows, and I'm not going to the Citrus Bowl. Like everything for me is over. I had no idea. I thought we were good. Meanwhile, you've been talking to a lawyer and you just reported me and there's a whole investigation. And I didn't know. So when HR came to ask me about what was going on, rather than cop to it, because the bottom line, when your HR partner comes and asks you, are you sleeping with your secretary? Trust and believe, we already know what's going on. They're already investigating your emails. Emails have already been got. Phone calls, phone logs have already been looked at. Other statements, other people in the bubble may have already been talked to. Complaints may have already been filed, and whispers are already happening. By the time you're sitting in the office and they're talking to you, understand that there's already been a whole investigation going on before this conversation has taken place. Have you ever been talked to by your boss or HR and then they open up that folder? They open up a folder and they got some receipts on how you're not doing your job or how you haven't been effective, or they talk to your business partner or the business that you support, and they've already got the information that they need and they're going to talk to you with receipts. Hello? Come on now. So instead of manning up and saying, I did it, and maybe own it and go out a little more quieter, or potentially, claim I need employee assistance. I had a psychological lapse, whatever, anything. I've got a sex addiction, anything that could have maybe, okay, we've sent coach off to treatment. He's in rehab. We can't talk about it. It's an employee matter and he's gone to rehab. I mean, look, anything, stuff happens, right? He lied. He lied. He was given his opportunity to tell the truth and come up with a good, cute answer that may have sent him off to rehab for a year and an assistant coach takes over. But he lied. Okay. All right. Let's finish this up.
Too soon to answer that, honestly. I haven't been, my mind.
That means yes. But
No, not necessarily.
No, go ahead. You're not. I understand
Okay,
why you
stalking
want to
isn't-
answer that. But those could potentially formulate a stalking charge. I might agree with you that the stalking, as it's framed in the complaint, isn't the predicate for the home invasion. I get that. But that illegal entry or potential allegedly illegal entry and then the text message could do that.
assuming it can show intent to harass and all these other elements
Understood.
that I would have to analyze, which is why I'm saying I'm not going to answer that until I actually analyze the fact.
That's okay. I've got my answer. Go ahead. You can keep with your argument.
But it's important though, as to the felony. I mean, a felony it is much more serious than a misdemeanor. So if the stalking fails as to going there with the intent to stalk, breaking and entering with the intent to stalk, that would have to have been a second or third act. You can't go and do something.
I'm not saying I'm disagreeing with you.
Okay.
I'm just saying
Thank you.
that you made a statement
Understood.
that I might disagree with, but go ahead.
The government also pointed out that there, in the fact pattern that she just relayed to you about Mr. Moore walking towards the complainant while he was holding the butter knives. I'd like to point out that the prosecution or the charging agency, they're the ones who get to choose. They didn't charge him with assault or aggravated assault or any assault. They looked at the facts and didn't even ask for that. So to describe him as dangerous and assaultive, they didn't even see that as assaultive on that day. I just want to make that point. Finally, the prosecutor also stated that there was further conversations with the complainant to flush out more of the history. That conversation occurred prior to the swear-in. The in-depth conversation with the complainant was documented in the police reports and is on body cam, video, audio and video. And at no time does she describe a history of domestic violence or a history of stalking. And one more thing is, I was getting to Eichler, paragraph 6 the government tried to say that Eichler can only be applied to cases where it's a probation agent, probationer relationship, that it's limited on its facts and should be seen as limited in its holding. Eichler actually states that the language from Eichler is this, that under Spalding, which is a case that they're citing, a reasonable individual is a reasonable person similarly situated to the victim, which necessarily means that we must consider Meyer's chosen occupation, training, and job-related responsibilities as part of our consideration of the circumstances or situation. It doesn't say we must consider one is a probation agent and one is a probationer. It specifically generalizes to the relationship between the parties, the employer-employee, occupation responsibilities. I just want to make sure Your Honor recognizes that Eichler is broader than what they are trying to make it be. Finally, with regards to the omission of the information of the employee-employer relationship, putting something on the record matters. That's why we have a record. That's why we rely on a record. That's why we make a record. If the employee-employee relationship isn't on the record, we cannot assume that she had any knowledge of it. Finally, if there was notice at all that, well, he's the head coach at Michigan, who knows that the complainant was his executive assistant? I put out there that is certainly not anything someone would take for judicial notice. I suspect that nobody knew that relationship until this incident happened. And if I may just confer with co-counsel briefly. One last point to make is the prosecutor presenting to Your Honor that it is a known fact that Sherron Moore is the head coach at Michigan. That known fact would be from the media, from the news, from various other places, and it's improper for a judge to rely on that kind of information at a swear to.
Let me just ask one other question. Let's say, hypothetically, go through the entire thing. We have the evidentiary hearing. What do you believe the proper remedy is?
I think the proper remedy is it's a couple step process. I think first, after the hearing and the evidence is presented, and Your Honor makes a determination of what was not true or recklessly presented because it's unsupported, and that is taken out, and then the omission is put back in, I believe it would be on Your Honor to.
So no, this is not an evidentiary hearing. This is actually a motion for them to have an evidentiary hearing. I mean, initially his lawyer wants the charges dropped because she doesn't feel like they have a valid base. But this was to have a evidentiary hearing because of a omission of very key information for the magistrate to make a valid decision for an arrest warrant. So they're going to actually, you know, I'm not going to spoil it, but this is not the evidentiary. This is actually a motion to have a evidentiary hearing. So just so you know, the person who asked, Mercedes, they are motioning for a evidentiary hearing. So this is the two sides. We're at the closings right now. So he's asking what's the remedy, and she's giving a very long answer. My answer would have been number one, drop the charges, drop this case. Number two, if I can't get that, then I'll take the evidentiary hearing. But you know, these ladies talk a lot, but I mean, she's effective though. She's very smart. Okay. I just wanted to clear that up.
Then evaluate based on controlling Michigan law to determine if there's enough probable cause to support this not only the warrant, but the swear to. Not only the swear to for the warrant, but the complaint itself. The complaint has to be accepted by the court. The prosecution doesn't just, I mean, there is a process for Your Honor to review a complaint and accept it. So I believe a dismissal of the complaint would be appropriate remedy. I think a secondary remedy would be to suppress any and all evidence obtained after the arrest.
I guess maybe I'll put it more directly. Let's say you were to win on everything.
Yes.
There would be nothing that would prevent the people from seeking reauthorization.
That is correct. And it is my belief, based on my review of the materials, my investigation of this incident, that they wouldn't have probable cause to make these charges. I don't believe they have probable cause to make these charges.
Regardless, you just don't think that there is.
I believe when presented fully and fairly to a magistrate, I believe there is not probable cause to support these charges.
All right.
And I believe there's less probable cause now than there was when the incident happened.
I don't know what that means.
I believe that the evidence that has now been collected will show that there was not stalking.
Right, but
That's what I'm saying.
right now, I'm not dealing with any of that.
Right.
You're, for the purposes of this motion.
Right, you're asking me, I believe the question was, let's say I win and everything's dismissed, they can go and just refile. That was the question, correct?
Yeah, I mean, there wouldn't be nothing other than the fact that there might not be enough evidence to do so to prevent them from doing it, right?
It's my belief there won't be enough evidence to do so.
All right, very good.
Thank you.
Thank you. All right. Thank you, counsel, both of you, for your argument and the manner in which you answered the court's question. The court does appreciate it. I'm going to take a break. I will come back with my decision. Why don't we look at it this way? Just give it time to come back. It may not take me that long to formulate everything, but come back on the record about 4:15. All right. You'll make sure that they know can get them down to where they need to be. Court stayed in recess.
All right.
Okay, so he took a break and then now we're back. Look at that. Look at this wonderful edit. Okay. Judge Simpson is so good. Wait till you hear what he has to say. I think he was very fair. And ma'am better get her shit together. This ma'am right here, the prosecutor, ma'am better get it together and get her paperwork and sharpen her pencil, get up into her computer. And baby, ma'am better not be sitting at that table alone next time they meet, because his lawyers, baby, they are not playing with her. When I say Miss Ma'am, ma'am better get on her business and open up her law books, get up there into the Westlaw, get those investigations popping, because ma'am, you're in trouble. Okay, you about to lose your case.
State of Michigan is now back in session. The Honorable Judge Jay Sessions is back.
You may be seated. Thank you. Got it. Back on the record in the case of the People versus Sherrone Moore. Counsel is present as well as the defendant. And I, first of all, again, want to thank counsel for their well thought out arguments, and most of all for answering the court's questions, which since the filing of the motion for Frank's hearing and to quash the arrest warrant have been part of this court's this extended thought process. The important thing to request for an evidentiary hearing pursuant to Frank's is, the first thing to realize is that in Frank's, in the Michigan Supreme Court has made it very clear, Frank's, the requirement of an evidentiary hearing and the like based upon Frank's is the floor and not the ceiling. Michigan, I think, as the people have acknowledged, allows greater leeway and discretion for courts to hold evidentiary hearings regarding issues involving a search warrant, arrest warrant, or warrants, where it is in some way demonstrated that there is either evidence which is intentionally or unintentionally, in certain respects, misleading or false, or where there is almost a reckless indifference for the truth. This case brings up sort of a different issue, but brings up the issue of an omission. What is clear from this court's perspective, at least, is that an omission in certain contexts can be more damaging, more problematic, more troublesome than what might be an intentional misrepresentation. In either way, or in any event, this court is of the belief that at every proceeding, every representation made to a court should be a full and complete representation to the court, so that all the parties can receive their due process. That includes the people, it includes the defendant, and anybody else coming before the court. The defendant wishes this court to have an evidentiary hearing regarding the issues, but fundamentally it's focused around certain portions of the omissions and sort of the context, particularly as I gather from the defendant's argument, and what has been a concern of the court is the context of the relationship. The people, on the other hand, don't believe that the court should hold an evidentiary hearing and that it would be an abuse of this court's discretion, which it has the discretion anyway. But it would be an abuse of that discretion to hold an evidentiary hearing. An abuse of discretion, what is very clear from the case law, only occurs where the result of the court's decision or use of its discretion is outside of the range of reasonable outcomes. I don't believe that granting an evidentiary hearing in this case would be outside the realm of reasonable outcomes at all. And just by way of context, in looking at the swear to by Officer Walker, what's clear, and also from the court's question, I think the parties realized where the court was going and should have. The initial part of that swear to is not set out by the representations of the alleged complainant in this case. It's all set out by her attorney, Ms. Sherron. Virtually every statement is a rendition of what Ms. Sharp said to the police. It isn't until a little bit later into that swear to that you get into particular statements that are made by the complainant in this case. When one looks at the Eichler case, one of the things that realize and where the defense is heading is that the context, and I read it as broadly as the defense does, that context to stalking charge, context of that relationship is critical to an assessment of that relationship and whether or not there's this harassing behavior or stalking going on. As I said, I can only imagine, but this court doesn't know what an executive assistant to a football coach does. I don't know if phone calls or messages might be exchanged all times of the night. I don't know any of that. I can only presume that if they are the executive to effectively a CEO, the range of their responsibilities, duties, communications is vast. But again, I don't necessarily know that, but it's something certainly that the court should have been informed of during the swear to. It's gone without any rebuttal that the phone calls that were alleged or alleged to have occurred during work hours, occurred during those times at which I guess most might think communications would occur. That the written messages in terms of text were admittedly employment related, at least is what's been represented to the court. I don't know why that wasn't given to the magistrate. I think that the evidentiary hearing would be necessary because there's no mention of the employment, that context given to the relationship. The context during the swear to is a one-sided rendition of things by someone else. It by no means would constitute a full picture. More important, and it may go to the defendant's argument, although they didn't place it this way. I asked what might be particularly false in their statement. That's a tough question to answer. I appreciate the response that I got. But really, I think that the falsity really comes in the way that it was sworn out. It at worst is false and an outright lie. excuse my language in that regard, or at best, it is misleading. And particularly when it talks about the 10 to 12 phone calls and text messages, there's not one mention of the fact that those to which they could determine were work related. There's not a mention of it. That is a huge, in this court's perspective, that's a huge omission. Because immediately afterwards, again, there's like a statement from the complainant about these 12 calls, making them seem as though they are somehow related to some type of harassing behavior because there's nothing on the other side to say what it may be. And then the immediate statement afterwards is a text message that came after the incident or later on the 10th, after the issue regarding the complainant. Frankly, I think that was intentional. I think it was intentional to place a context without saying it. Give the court a context. If you look at the very beginning, that he's this monster, he's this person that's been doing all of these things, been harassing her for months. You lead that down into all of a sudden this day comes along or the 8th December comes along. There are these 10 to 12 phone calls, which one might presume would be a continuation of the harassment, but we now know are not any type of harassment. And then the December 10th incident. I don't believe a lot of times in coincidence. I don't believe that things happen all the time by accident. I agree. I think that that was an intentional misdirection to the court in terms of what this should look like. That doesn't mean that I would end up any place different than where the magistrate was, but the magistrate was owed the benefit of having all of that information prior to making that decision. It is in this court's mind a glaring omission to leave out or frame this relationship only in one way. That doesn't mean that it doesn't intertwine itself between the personal and the professional. It doesn't mean a lot of things, but this was not solely this personal relationship. And the magistrate should have been able to look at that and determine what it would be. That you can tell right on the surface. I would suspect as you dig deeper, there would be other issues that aren't painted in their full context in terms of what happened. So for those reasons, the court, in exercising its discretion, is going to grant the motion for an evidentiary hearing in this case to be held. And counsel, I'm going to have a couple of questions for you. One is in regard to availability, and I would indicate to the parties that I would like to hold the PCC date if possible. So I'm looking at getting to this in quick fashion. The other issue I would have, or question that I would have in setting a date, is what witnesses you would anticipate calling, and I'll start with the defense.
Have one moment, Jeff.
You may.
This lady is good. Good. Wait till you hear her answer. If you didn't watch this yesterday, this actually happened yesterday, guys. Happened late yesterday afternoon. It took roughly about 2.5 hours because they ended up taking a little bit of a break. After he heard the arguments, he took a break for about 45 minutes. Maybe it was an hour. I can't remember, but he took more time than he said he was gonna. But This was so good, but this was funny. His lawyer, he's got a good lawyer. He is a bonehead and he was stupid. He's not a good guy. He's a horrible husband. He's all of those things. But he did get himself a good lawyer. I'm gonna say that.
So the question was, what witnesses will I be calling? So it would be the government's burden of going forward to show that this was done properly. So I guess maybe I can respond after they tell me who they would be calling. I don't know that I would be calling.
Judge Simpson is so funny. You see how he just finds everything funny, but it's like Judge Simpson, she's not dumb. It's not her burden. It's not her. This isn't for her to prove. She just laid the smackdown on why this is some fuckery. So this is her situation to prove. But he gave her the win, so he wanted to give her the opportunity to give the witnesses first, and she gave a really good answer. I think that's why he's laughing, because she gave a very good answer. Let her tell who she bring in, and based on that, I might throw a few people in, but you know what I mean? I might not need to bring anyone because it's her burden, right?
Anybody once they put their case on.
Really doesn't matter to me who goes first, because I'm gonna get to where I'm gonna get to. Do you have what witnesses you would anticipate calling? Understanding, and both parties just need to understand, I think I made it clear as to where my reservations and concerns are. And you folks are gonna know those witnesses that would be able to clear it up the best for the court. So.
And off the top of my head, Your Honor, I think the court, I would imagine, would want to need to hear from Detective Welker, from, I would imagine, the victim, and from Ms. Sharp. Whether
I want to hear from Miss Sharp. And now that Miss Sharp becomes a witness, if Miss Sharp becomes a witness at Boothang's, in this particular situation, is that going to create somewhat of a conflict for Miss Sharp and her client? That I'm sure she's trying to get a coin from University of Michigan. I'm just going to call that out. Is Miss Sharp, you're getting ready to be a witness now. You made yourself a witness by giving a statement to the police for your client. I wonder if that's going to have an effect on her representing Boothang in an action against the university and SIR. Okay.
I should present to the court anybody other than those three is something I would, I guess, ask for a little bit of time to think about. Those seem the obvious ones, Your Honor.
Understood.
And if the court, I mean, I get it's my burden, my presentation, but I am mindful of the court's thought process, continue to be appreciative of the court's candor. If there are witnesses that the court would like to hear from, I would consider it my obligation to bring those to Your Honor.
Well, let me ask this.
Does this lawyer seem like she wants to be told, she wants to be guided, she wants a work assignment? Like, I'll indulge Your Honor and see, is there someone specifically you want to see? Okay, so that's going to make the assumption that, you know, I'm going to need to hear from these people for you to either prove or not prove your case, right? So it's like she always wants a damn cheat sheet help. Do you guys notice this? It's fake deference. I think she's definitely she's phony baloney, but I think she also wants help. Just catch her. Just see the way she moves. She always wants to be led in the direction of where to go, but I think Miss Michaels is actually really good at her job. And Miss Lady over here, she wants help. I can't wait for this next hearing. I'm not going to lie to you. This has actually been pretty interesting because we're going to get to see the dog and pony show next time. and the complainer, the complainant, the victim, the alleged victim, the complaining witness, however I should say that best at this point in this juncture, may have to make an appearance. Okay, so we're going to hear from Welker, the detective. We're going to hear from the lawyer who made the complaint for her client. We're going to hear from the complainant, and let's hear who else.
Were there officers that were part of the interrogation process or the questioning of the victim in this case
There were a couple, yes, Judge.
that were, so, and the only reason I say those is because Detective Welker presumably would have received that information from them, or at least that's a possibility.
Some of it, yes.
Okay, so I think the officers that may have interviewed the victim in the case
There's at
would,
least two more.
See how he's helping her? I don't think he's trying to help her. I just think he's very engaged and likes to talk. And it's like, Judge, stop helping her. She is a freaking girl. Sit down. Most of these judges would be like, well, just file your list with Miss So-and-so and thank you very much. You know what I mean? Like, he's actually helping her talk it out. We're going to have a talk with Judge Simpson.
Or that I can think of that often.
Stop helping Judge Simpson.
sure.
I would agree that Detective Welker will be a necessary witness. And then I don't know the name offhand, but the officer who had a body camera on at the scene.
Ooh, if we get to see the body cam footage, it's always so good to have a good body cam exhibit. Okay, Exhibit A.
Would likely be a witness or potentially for purposes of impeachment if necessary.
But that officer, and maybe that's who I'm kind of referring to, because that officer was one that I can't remember. I think somebody referred to it in something.
Michael Barlow was the original respondent.
Great. That's it.
That I would think would be for sure.
Yeah.
There were a multitude of other officers that came and went.
In defense of Miss Michaels, I mean, this was like the patrol officer on duty. I guess she would need to have the police report in front of her, but she knew Welker. Welker is the detective. And but yeah, the officer with the body cam footage.
Okay.
From that apartment, all of whom had body worn camera. Some asked additional questions, some asked mostly repeated questions. There was one officer who did a follow-up phone interview, whose name is escaping me right now, Peterson. And that is a recorded follow-up phone call, Patterson.
Now, the prosecutor really should know that police report. Now, whether she knows it and has committed to memory or not, I'm cool with not, but she should have it accessible in her folder or her notebook, whatever she uses to be organized for a particular court appearance. Like, she should have that particular, considering what the nature of this particular motion was about, she should have that police report right there with her with all of the details, the affidavit, everything.
With the victim. So those are two for sure. If you're looking to hear from and see body cam of interactions with the victim, so Escobar, Luarca, and Patterson.
Okay.
If council or court would like all of those who responded, who had body worn camera, there's duplicated effort there, but
I don't, no, well, the court
Y'all, I
would have
dropped
to see
something,
body
my
worn
bad.
camera. As long as there's an admission as to its foundation, I don't know that we're gonna need the officer there per se. I mean,
Yes, we can talk about that. That's probably, we could probably stipulate to the foundation of those body worn cameras. There was the initial officer who talked to the complainant, and then later on, maybe a half hour later, there was a follow-up interview on site. I'm not sure if it was the same officer or not, but we'll make sure we figure out which body cams are relevant.
okay. Anybody else you can think of?
That's all I can think of.
All right.
need or want the officer that took statements from the defendant, as those are also referenced in the script.
I think that would also be prudent to have that officer.
Thank you.
No, she was here from the first appearance. Scatterbrain's been here since the beginning. She was the one at the she was there when he was arraigned. Do you want me to play it? I mean, well, girl, we've already gone almost 3 hours. I'll make a SHERRONE more playlist because I think I've done, maybe this could be the 3rd or 4th video. But we did, remember, we looked at his arraignment. Remember when he was sitting there looking shell shocked? He looked like a prisoner of war or something. Like he was looking really despondent. It was a mess. He was in that white jumpsuit when he was first arrested. Then we saw his first appearance when he came with his wife. And I think I did an initial kind of, girl, this is what happened. So maybe this is like my 4th video. I'll make a playlist, okay? So you guys can get caught up. It's interesting, right? Yeah, he's a cheat. Yeah, he's not a good guy. But I don't know that there's any heroes in this story. I'm going to be honest. The only hero I'm seeing right now is the Honorable J. Cedric Simpson. That's the one hero in this whole entire story for doing your damn job. Okay? That's my hero for today. Okay? Sir is doing his job on that bench. I mean, he's so good. I like him a lot. And Miss Michaels is good too, even though her client is suspect. I don't know that he's guilty of what they're charging him with, but he is guilty of having an affair at work, and he's already been fired for that. But I don't know that he's guilty of what ma'am is trying to accuse him of, but we're gonna let the courts figure it out. Girl, remember he was looking like he looked like he was a mental patient. All right, let's finish this really quick. We only got like 3 more minutes, and then I'm gonna let y'all go. Okay.
Suggestion. Council and I can communicate about hoped for, anticipated, expected witnesses. If I then compile a witness list, serve it on the court and council with perhaps a reference to just very minimal first responding officer, the phone interview of victim. If then there are additional witnesses that anybody would like to hear from, I can consider it my responsibility to make sure.
All right, very good. Second.
That works, yes.
Okay.
Lambo, would you stop?
Okay. I'm just looking at that list. It's going to be an all-day fair release. So those of you that practice before me know that that's usually limited for me. However, I would have and can cancel dockets. I would have March 2nd and March 9th available. And if I cancel that, you have this also right. This is, I cancel. So I would have March 2nd, March 6th, or March 9th.
Currently have a murder trial set to begin March 9th. Might be resolved in the process of doing that. So in light of the 9th currently being occupied, the 2nd is the best bet,
Okay,
followed by the 6th, followed by, in the moment, not the 9th, but they may all wind up being good from my perspective.
got it.
I prefer the 2nd, March 2nd. I'm available that day.
Okay. Well, it's not Groundhog Day, so I'll be good. March 2nd, 9 a.m. Okay, and we'll set the evidentiary hearing in this matter for March 2nd, 2026, 9 a.m. Counsel for the defendant will prepare an order consistent with the court's ruling today.
I will do that.
All right. Is there anything else from either side?
Going on.
Thank you.
No. One question I did have, I know that at our probable cause conference, there were issues regarding documents from the University of Michigan. You had indicated that you may ask the court for a subpoena. I was having my staff on the out look for that. Has that been resolved in any way or not?
I have not done that yet. Why don't we have a conversation about that as well? Sure, we are.
All right. Why don't you guys talk about it? Just let me know. I was curious because it's one of those things on my checklist that wasn't checked off, so. Folks, thank you very much.
Thank you.
Bond will continue. Court stands in recess.
All right.
Okay, I'm back. You guys, was that was good, wasn't it? Okay, that was good. When I watched that yesterday, I was gonna call you guys up yesterday, but I was like, y'all, it's okay. We'll talk about it tomorrow. It was good though. I felt like I learned a lot. Judge Simpson is one of those when you watch, like you might actually learn something. I'm not gonna go on and on and on, but I enjoyed that thoroughly. How's everybody doing? Yes, it was good, right? Mark your calendars, March 2nd. Okay. Okay. It's been almost 3 hours, which seems to be what we're trending right now. And baby, yeah. Okay. I'm trying to think of what I'm gonna do. I gotta go. What time is it? It's almost 1. It's almost time for me to get on mom duty. Do you guys want to see his firing document? You want to see his firing document? Look at me. Girl, I sound terrible saying that. Hold on a second. Do you want to see his termination letter? Hold on. Let me see if I can find it in here. I just clicked on the wrong thing. It's like, why isn't it? Oh, here it is. Okay. It's funny because when I look at the press release, oh, yeah. Okay. I think I need to say open with, can I open this with Chrome? Open. Yeah, I like that when he's asking questions, like I feel like, oh yeah, that was a question I would ask. Yeah, that's a good question. Like he definitely provides those insights, right? Oh, let me just pull it off the internet because I don't know, for some reason this is pulling up like a picture and annoying. Let me see. I think it was on. Hold up. Okay, guys, let me just make sure if you have not hit the thumbs up yet, what you waiting for? I don't know what you're waiting for. Go ahead, hit the thumbs up for me. I so appreciate it. Let's see. Is this it? Oh, here it is. Come on now. Why is this showing like a picture? This is so annoying. Okay. Okay, I had to kind of like rethink what to do. If I share my screen, stop sharing, share screen. There it is. Okay. Okay, can you guys see this? Golly, my God. Can y'all see this? Are we, oh, we're not seeing yet. Okay, dear this is his termination letter. How did it hit the streets? Michigan is a public university and it was obtained in FOIA request. It's all over the place. So this is the real deal. This is his this was obtained via FOIA. Not by your girl, but this is all over the place. Okay. Dear Sherrone, can y'all see? Okay. Dear Sherrone, this memorandum confirms our discussion on December 10th. That's the date in hand, right? They were talking about between December 8th and 10th. Discussion of December 10th and serves as official notice that your employment with the University of Michigan Athletic Department is terminated for cause, like you were fired for a reason, effective immediately. Following hotline reports alleging inappropriate relationship with a staff member, the university conducted a thorough investigation into your conduct. The investigation findings indicate the following violations of your employment contract. Number 1, inappropriate relationship with a staff member. You engage in an inappropriate relationship with a staff member. This conduct violates section 4.02C, conduct which offends against morality and public decency and in a reasonable judgment of the university could harm the university's reputation, and which includes violation of the university's policy as misconduct. Your conduct violated SPG 201.97, supervisor-employee relationship, which is defined as serious misconduct. So there's like 2 different levels of misconduct here, not only the morals clause, but also just in terms of a subordinate. Okay, that's number 1. And then number 2, dishonesty during investigation. You provided untruthful statements during investigative interviews regarding this matter. You lied. Okay. That conduct violates section 4.02, fraud and dishonesty in the performance of any duties and responsibilities of your contract, which includes providing untruthful statements during an investigation. Based on these violations, each of the following would independently support termination for cause. Your appointment is hereby terminated with cause, meaning we're not paying out the rest of your contract, okay? Effective immediately. You are not to contact any university employees or student athletes. You are not to visit any athletic department facilities. Next steps, you are not eligible for rehire for University of Michigan. Your personal items in your office will be packed and mailed to you no later than December 23rd, 2025. For questions regarding benefits, please contact the benefit office. Please contact Tiffany to return your university belongings you may have, such as iPad, cell phone, etc., no later than December 15th. We will be in communication to make arrangements to retrieve your dealer car. Okay? Ward Manuel. Okay? Director of athletics, etc., etc., etc. Okay, did you guys hear me? I think you guys heard me, right? I hope. Hold on, let me make sure. I felt like I was outside for a second. I hope you guys heard me. Did you guys hear me? I don't feel sorry for him either. I'm not gonna lie. I mean, cheating on your husband, cheating on your wife, a cheating husband is never a good thing. A cheating spouse, let's get this straight. Cheating spouses, no bueno. Okay. You can't have an effective marriage if people are cheating. That's it. That's all. Okay. If you're lying, cheating, being deceptive with money and things like that, it's all bad, right? Ma'am, Miss Girlfriend, I don't feel sorry for her either, unless it comes out that she was being psychologically controlled. He had some sort of pull on her. He groomed her. He did something. Like, give us the story. Provide us the receipts so we can give a shit. Otherwise, if you willingly engaged in a relationship with a married man and this is what's coming of it, I don't feel sorry for you. And if your lawsuit falls apart because your lawyer is fugazi, telling a very biased story, because you knew that you could, and you weaponized the legal system in your community to file a report that made this dummy look a certain type of way to effectuate a particular result, shame on you. Okay. So I don't know. We're going to see. We're going to give ma'am a chance to come tell her story. But if she was over here playing with people and her lawyer was playing to try to get a payday, to take him down, to get him fired, to get some money, nobody respects that. No women should stand behind that type of behavior at all. Unless this guy was able to master magician her, which is possible because there are people out here that do stupid things. Just like there was no excuse for Juliana Margulies the other day. You know what I'm saying? Like, I don't know. I don't feel sorry for this lady yet. Show me a receipt to make me give a fuck. But otherwise, you shouldn't have never gotten involved with that married man, and that married man should have never gotten involved with you. And this is what happens when you engage in that type of foolishness. If he wanted to have a girlfriend, he needed to get a divorce. And if you wanted to have a boyfriend, you should have found one that was single. Okay, that's my summary on today on that one. You guys tell me otherwise. Okay. Okay. Okie dokie on that. Okay, guys, March 2nd, we're going to have some testimony. And the wonderful thing, can I say one more wonderful thing about the judge, is that he broadcast his own Zoom on his own. He's a YouTuber, guys. He's got his own YouTube channel and he goes live with all of his hearings. So we don't have to worry about this news company or that reporter or any of that. His courtroom is open and he's always, when he's on the bench, baby, you know what I'm saying? It's on YouTube. Yes, he's awesome. Okay. All right. Let me stop. See why I can be more serious when my camera is off. When I turn my camera on, I get silly. I need to see if I'm off. Girl, don't worry about being off. It'll be fine. Have your earbuds so you can listen when you're charting or something. And the replay is real. Replay is real. So it won't be stopped for not hitting. So it won't be stopped. No, we don't, girl. No, it won't be stopped because number one, I would never. However, so from a blogger perspective, no, we don't do lame shit over here. And then from a can't stop, won't stop perspective, no, it won't happen because Judge Cedric Simpson is about his business. So thank God, no, we don't do lame shit over here. This is lame. This is sucker free. Okay. Okay, we are sucker free over here. We don't play that. We don't play that shit. Okay, let me stop. Okay, I'm being extra silly. Okay, you guys, have a wonderful day. Did you guys hit the like button for me? Do I need to check? Am I going to be oh so sad and disappointed? I hope not. Let's see. Let's see. I really. Oh, what's to? Ooh, okay, you guys. I don't want to say too much, but tomorrow, number one. Latasha Daniels, okay? The side chick murder trial. Side chick murder trial. Where is Bible Lady? Is Bible Lady around? Bible Lady, side chick, Latasha. Oh, okay, good. Everybody who came in, we got all the likes. All the likes are accounted for. Thank you. Praise God. Side chick is going to be sentenced tomorrow, I think, at 9ish. Let me look at my calendar. Tomorrow is the 19th. Baby, we got a full calendar. This is what I'm going to say. You guys may or may not remember there's a certain divorce going on in Atlanta that I need to be on Zoom at 9 at don't worry about it. When I go live, you'll know. I can't go live with the proceedings, but I need to be there live. You know what? This is what I'm going to do. Because there might be victim impact statements. Don't worry. I got you guys. This is what I'm going to do. I'm going to just tell you guys. Okay. Like other people can't hear, but what I'm going to do, as soon as Latasha Daniels sentencing goes live, we will be live with that. Behind the scenes, I will be managing that divorce business that I have to attend because we can't show that anyway. Because a certain every man wants a woman. Okay. A certain person does not want the media broadcasting their divorce, and I get it, but I have to get the tea firsthand. So I might just I'll be able to handle it. Don't worry. I cannot forget to handle that business in the morning as well. Okay. There's two important things happening tomorrow morning. One's going to be I'll be broadcasting, and the other one I'll have to be behind the scenes and then come back with a full report. You understand? You follow me? Okay. All right, guys. Rich Auntie says, thank you, Fran, mods, and Bougie Gang. Okay, my sentiments exactly. Let me let you guys go. Can you turn your hype on? Hype is on. Hype, I don't think you can do until after I turn this off, like after I end this live. Okay. As soon as I end this live, remember if you haven't hyped anyone this week, you get 3 hypes, and you can hype me back to back. You can give me all your hype points. So you get 3 hypes a week, and you can give me all of them, please. Okay. Give me all of them. You're going to celebrate your birthday. Happy birthday. Happy birthday. I hope that you have a wonderful birthday. Are you a Pisces? What's today? It's not Pisces season yet, but it almost is. Is it still, what is it? Are we in Aquarius? Yes, we're still Aquarius right now, right? Happy birthday. I hope that you had a wonderful one. Yes. Everyone say happy birthday to our friend. Thank you for going to celebrate my birthday. Okay, I hope that you have a wonderful birthday. I hope that you have a good cake or whatever it is that you like to help celebrate your birthday. And you get all of it and plenty of it. Lots of hugs and kisses and lots of calls from the friends and the family and a nice good dinner tonight. So have all of that. Aquarius season. It's my birthday as well. Bridget, happy birthday, boo boo. Happy birthday. Happy birthday. Happy birthday. Lots of happy birthdays in the chat. You guys are amazing. Y'all, I appreciate y'all so much. This was so much fun. I love a good hearing. So I'm glad we got to get into this. Anyway, y'all, we have it on the calendar. The 22nd. Mai Tai. All these birthdays. Look at all these birthday babies. Okay. Happy birthday. Happy birthday to all of my Aquarius babies. I love you guys. I hope that you enjoyed your birthday season or are enjoying your birthday season. And I'll see you guys later. I think I'm going to be live over on Love Lies and Lace Fronts because I got to get over there. I did not go this morning because I had a doctor's appointment. If you want to know what all that was about, either go to members or go to the beginning of this live and I talk to you a little bit about it. Otherwise, I'm gonna have to let y'all go. I don't even want to commit to coming back later here because I missed this morning over there and I'm going to go live unexpectedly over there, which I never go live in the afternoon over there, but I am today after I go get Farah. Okay. I'll see you guys later. Bye guys. Should we do the outro? Let's see. I mean, this video is long enough. Let's just say goodbye.